All right. Good morning. It is April 14th. It is 9:02 a.m. and this is a regularly scheduled meeting of the Oil Conservation Commission. I'm Adrienne Sandoval, Chair of the Oil Conservation and Director of the Oil Conservation Division. Would the other two commissioners please introduce yourselves for the record?
Thank you, Madam Chair. My name is Greg Bloom, and I am the designee of the Commissioner of Public Lands.
Madam Chair, Dr. William Ampuma, a designee of Energy Secretary.
Also with us today is Florine Davidson, clerk to the commission, and John Kryenkamp, who is counsel to the commission for today. All right, first item on the agenda, commissioners, is there a motion to approve the agenda for the day?
Madam Chair, I move to approve the agenda for today's meeting.
Is there a second?
Madam Chair, I second.
Mr. Kryenkamp, would you please do a roll call vote?
Yes, Madam Chair. Chair Sandoval?
Approve.
Commissioner Bloom?
Approve.
And Dr. Ampoma?
Approved.
Thank you. The motion passes and the agenda is approved. Next item on the agenda is approval of the March 10th, 2022 minutes. Commissioners, have you reviewed the minutes and is there a motion to approve them?
Yes, Madam Chair, I had the opportunity to review the minutes. They looked just fine, and I move to approve the minutes from the March 10th meeting.
Is there a second?
Madam Chair, I do second.
Mr. Kryenkamp, would you please do another roll call vote?
Yes, Madam Chair. On the motion to approve the meeting minutes, Chair Sandoval?
Approved.
Commissioner Bloom?
Approve.
And Dr. Ampoma?
Approved.
Madam Chair, the vote was unanimous.
Thank you. March 10th minutes are approved. Next item on the agenda is case number 22719, application of the Oil Conservation Division to amend rules 1915.2 and 1915.7 in MAC. Let's see, do we have Mr. Tremaine?
Yes, Madam Chair, this is Jesse Tremaine for the Oil Conservation Division.
Great, I can hear you. I did not see any additional entries of appearance. Were there any other parties on this?
Madam Chair, members of the commission, Michael Filderwort with Santa Fe Office of Holland and Hart, appearing on behalf of the New Mexico Oil and Gas Association.
Okay. Mr. Tremaine, would you go ahead and give kind of an overview for the commission of the petition, please?
Sure, thank you, Madam Chair. This case is OCD's application to amend Rule Parts 2 and 7 with the general purpose of modernizing the rules to reflect and enable practical practices and workflow for the Oil Conservation Division. This rule, kind of at a high level, provides for electronic filing by operators and interested parties, provides or reflects and updates the rule to conform to OCD's district reorganization. Also provides for, we think, improved coordination with BLM and other potentially other agencies, and also works to condense and reorganize certain sections that in the current rule touch on similar subjects but are in separate sections. So the goal there is to simply reorganize for clarity purposes. That's it. OCD thinks that this is really just an update to bring this rule up to speed with current practices and the way the world works in 2022, and does not reflect any significant substantive changes to OCD practice.
Thank you, Mr. Tremaine. Mr. Feldowert, I'll give you an opportunity if you have any comments.
Thank you, Madam Chair. I don't have any comments at this time.
Commissioners, do you have any questions for Mr. Tremaine or Mr. Feldowert regarding the petition?
No, Madam Chair.
No, Madam Chair.
Okay. All right, well then I think what we need to discuss, commissioners, is one, if we want to move this forward and set it for a date, when that date would be, and then discuss what we want the procedures for the rulemaking hearing to be. Mr. Tremaine, by chance, do you have any of the kind of timelines laid out in terms of when the legal notice would be published, what 30 days from that might look like, any of those components?
Yes, Madam Chair, I do have a tentative proposed schedule if I can screen share.
Yep, let me give you permission. Hold on. Okay, you should be able to now.
On my end, it looks like I'm sharing, because can you see that?
Yeah.
Okay,
Yes.
so if you have specific questions, I can work through this. This proposed timeline works off of a proposed June 9th OCC hearing for the proposed changes, and the dates all work according to that proposed date. So that would be my starting point for discussion with the commission.
Ms. Davidson, are you on? Or can you hear me?
Yes, I'm on. Can hear.
Okay. Am I recalling correctly that the June 9th docket already has quite a few cases on it?
Yes, indeed, it has quite a few.
Okay. So we might, commission, we might want to look at setting a special date for this. Mr. Tremaine, so I'm just looking here. Okay, so it would be published in the Register on the 3rd. What would be the 30-day? So there's a 30-day requirement for public comment at a minimum. So that would put us June 3rd, roughly?
If we meet the May 3rd publication, I can never remember if May has 30 or 31 days, but I think if we, so by my math in my head, I'm saying that June 2nd would be the earliest that the OCC could proceed if we meet that May 3rd publication deadline. But I think to play it safe and let me run a day calculator here.
I guess while you're doing that, commissioners, does it make sense, I think, to look at a special docket for this rulemaking hearing?
I'm sure I'd be fine with that. Absolutely.
Okay. Mr. Tremaine, do you have a do you have an estimate on how long this might take? Do you think it will take more than a day?
I hope it will not take more than a day. I do not think that these are proposed changes that will require extensive testimony. Not knowing what other parties will bring to the hearing, I suspect that the OCD's presentation will take half a day, perhaps less.
Okay.
And in answer to your earlier question, I ran a day calculation, and June 2nd, which I believe is a Thursday, is 30 days from the May 5th date. So that Thursday, I think, is the earliest date that the OCC could hold a special hearing.
Okay. Commissioners, I'm gonna pull up my calendar.
I'm taking a look at mine, and June 2nd and 3rd would work if we wanted to reserve 2 days. 23rd and the 24th work for me as well.
I could do June 2nd and June 3rd.
Madam Chair, that works for me as well. School will be over by then, so.
Okay. So let's look at that. All right, so if we work backwards from, this is the fun part. We work backwards from June 3rd. We need to set, I think, a deadline for pre-hearing statements and any motions. And then a reply date, I think. And Mr. Krankamp, if I missed something, please jump in.
No, I think everything's fine so far.
Okay, so June 2nd, that's Thursday. We probably want pre-hearing statements at least, what, 2 weeks in advance?
Madam Chair, I think that if we're moving it 7 days, then I think we should just go, what I would propose is we go through this timeline and just move everything back 1 calendar week, which is 7 days.
Okay.
And that should get us to the appropriate deadlines. So for pre-hearing statements, pre-filed testimony, that's 10, we calculated 10 business days. It was May 25th. I think that makes it May 18th. Which is a Wednesday. Likewise, to deadline to complete notice requirements is going to need to be
That'll be the 3rd, right?
May 3rd, which is a Tuesday.
When you're saying, just so I can clarify, deadline to complete all notice requirements for which, what are you intending in that bucket?
That's a good question. I think that is the notice requirement for the OCC to provide notice of the hearing.
Oh, okay. Okay, so that's more of an internal deadline.
Yes.
Okay, so then if we did so moving it back a week from the 25th is the 18th. So pre-hearing statements, I would think, and motions would be due that day. Do we want to set a motion reply date? If there are any motions of a week after, so that would be the 26th. And then any motions can be decided on at the hearing on the 2nd. I'm sorry, the 25th would be a week. Okay, commissioners, so there's the requirement is, a minimum of 30 days for, legal public comment after the notice is posted. So we will be meeting that. I think generally, sometimes we've gone a little bit longer, but I think this is it seems like a relatively straightforward and simple, potentially rulemaking. So I think that 30 days is likely adequate. I would be comfortable, and we've done this in the past. Of allowing written public comment to come in before it's published in the, I think it was it after? Well, I guess we can allow comment at any point, I would say from now until that date. We've done that, I think, in the past. I'm trying to look at a past order and see.
Madam Chair, I'm not sure if my having this up is still helpful. I can take it down, but I'm just working back from the proposed date. And I think this means that there would be a deadline to submit the rule to the New Mexico Register today based on this date, because currently, building off of June 9th, we originally projected that deadline for a week from today. So I need to go back and check that rule, but I think that means that we would have a hard time meeting that.
Madam Chair, if I may,
Go ahead.
if I could just jump in just very briefly, and this is just a suggestion more than anything else. Mr. Tremaine, in terms of deadline for publishing in the register, so unless there's something unusual about these proceedings that I'm not aware of, the New Mexico Register has certain publication dates and deadlines. I think there's 26 of them or 24 of them per year. And so the next one is fixed at April 21st. And so that's the next deadline that they have. The next time that they publish would be the 3rd. So that, those dates generally are not, those dates are generally set rather than agency by agency.
Yeah,
Thank
I
you, Mr.
believe that's
Kine-Kim.
right. So you're still going to file, deadline to submit to the New Mexico Register is still the 21st. Because that's the due date for the register, I believe.
Yes, it is. And then the publication date would still be May 3rd for that.
Yes.
Thank you.
Yep, no problem. So, okay. So we have the pre-hearing, we have the motions, we're good with the 30-day. Let's see, I'm gonna pull up that past order again, sorry.
Madam Chair, while you're doing that, this is Michael Felderberg. I just pulled down, I don't know if it makes a difference or not, but I see that June 2nd is a division hearing date. I don't know whether that creates an issue for a commission date at that time or not.
We can have 2 WebExes running. I guess the only question would be whether or not it's going to be a conflict on the division side. I don't know if any of your witnesses will be involved in the hearing on the division side.
Madam Chair, I need to check with Mr. Brankard, who will be the division's chief witness. As I've indicated, we've discussed the June 9th date, so I will do that now.
Or, I think Mr. Brankard's on right now. Mr. Brankard, you want to chime in?
Thank you, Madam Chair. Yes, June 2nd is a division hearing date, and I will likely be in that hearing all day.
Okay. Then if we're only expecting this to go potentially a day, we could do it the 3rd. Commissioners, does that work? I think it works for both of you.
Absolutely, that would work.
That will work too for me, Madam Chair. It'll work.
Okay, I think we can keep the motions and the pre-hearing still a week from that Thursday, just to give a little more buffer. One other thing, in the past, commissioners for rulemaking, we have basically given me the authority to choose a hearing examiner for the case, so that, you know, I can focus more on the rulemaking instead of running the hearing and the rulemaking. Is that something we're comfortable doing again, is designating a hearing examiner for this hearing?
Yes, Madam Chair, that would be just fine. And I can't remember if we need to have a vote on that or not.
We will. We need to wrap all of this up in a motion, basically, both the dates and the procedures. I'm just trying to line out all of the pieces.
Very good.
Okay. For public comment, do we want to, so written public comment due on the 2nd? So by end of day, the 2nd?
Madam Chair, I think I recall a previous discussion that we need to leave this open until, I'm sorry, I can't remember if it was through the hearing or something like that. I don't love it because it doesn't always give us a lot of time to review the comments. I mean, I don't think we're going to have very many in this hearing, but just trying to remember what the rule was for that.
I think there has been some debate over that. In the past, we have always required it to be due the night before. There was something that came up at the last hearing. We allowed it to come in through noon, the day of the hearing. Mr. Kreienkamp, do you have any thoughts on that?
Well, yeah, so typically, I mean, in my experience is not with the commission, obviously, and my understanding is that you guys have your own procedural rule for rulemakings, but typically the procedure with other agencies is that the comments that are submitted through written comment period, usually it's the end of the day before the hearing, so usually 5 o'clock, but also during the hearing, you know, the public is able to submit, you know, written comments. Now that I know that your procedural rule, you know, provides for pre-hearing statements and sort of filings from people who want to participate a little bit more actively in terms of cross-examining and whatnot. And I think that that's fine, but someone who, just a random member of the public who wanted to come in and submit a written comment, they probably would be able to do that during the hearing itself, although I'd have to check your rule for that.
Okay, then why don't we just be consistent with what we've had to do with what we did last time and allow written comment through noon on the date of the hearing, so that over lunch or so be it, if any additional comments come in that day, the commissioners can review them. So that would be noon on the 3rd. For any oral public comment, do we want to try to set aside a time the first hour of the hearing, and then open it up again later. Make sure we've gotten, open it up, I guess, periodically, to just make sure we get everybody. Try to put a specific time to provide the public with some certainty. We've tried to do that in the past.
That would work for me, Madam Chair.
Okay, so if this hearing starts at 9, from 9 to 10, and we can encourage people to sign up in advance for a specific time slot. I think in the past, we have provided people who have signed up ahead of time with 5 minutes as opposed to 3. Okay.
That'd be great.
All right. Are there any other pieces we are missing for this hearing? I think that's it. Okay. So with that, I move to set the rulemaking hearing in case number 22719 to amend rules 19.15.2 and 19.15.7 NMAC to a hearing date of June 3rd, starting at 9 a.m. For this, any pre-hearing statements and motions will be due on May 18th. Any replies will be due on May 25th, and motions will be decided at the hearing on the 3rd. The commission will give the commission chair, myself, authority to designate a hearing examiner for this, as I feel necessary. For written public comments, they will be accepted anywhere from today's date all the way up through noon on June 3rd. Those should be directed to Miss Florine Davidson at the Wendell Chino building for written comment. For oral public comment, the commission will set aside time from 9 to 10 o'clock on the date of the hearing, June 3rd, for public comment. However, if there is not sufficient comment to fill that time space, then the commission will begin, the testimony in the hearing. Public is encouraged to sign up ahead of time with Commission Clerk, Ms. Florine Davidson. And if you sign up ahead of time, you will get additional time of 5 minutes. If you just show up on the day of, it will be a 3-minute public comment. Is there a second on that motion?
Madam Chair, I so move. Second.
Mr. Krankamp, would you please do a roll call vote?
Absolutely, Madam Chair. So on the motion, Chair Sandoval,
Approve.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Vote was unanimous, Madam Chair.
Great. Ms. Davidson, can you go ahead and get anything put together that we need to set that special date on June 3rd?
Yes, I will.
Thank you. All right. I think that completes agenda item number 4. Do we have Mr. Savage and Mr. Padilla?
Yes. Ernest Padilla for
Great.
Colgate Energy, or Colgate Operating, I'm sorry.
All right, so we'll move on to agenda item number 5, which is the status conference and adoption of final order in case number 21629 and de novo case number 21744. I think let's go ahead and do the status conference piece first, and then we can move into voting on the final order from last hearing. Mr. Padilla and Mr. Savage, can you just briefly provide, starting with Mr. Savage, basically an update for the commission on the next case? I believe the next case, I can't even remember when it's set for now, but when we're set for, and then, you know, what the next steps are. I believe this is a competing compulsory pooling case. So can you just provide a brief update, Mr. Savage, on behalf of your clients?
Yes, thank you. Good morning, Madam Chair, members of the Commission, Council. Darren Savage, appearing on behalf of Cimarex Energy Company. As I understand it, in regards to this case, Cimarex has been, thus far, has been granted, has been recognized as a party of record. Its application for a de novo hearing has been granted. I believe that there were some issues regarding the evidentiary hearing that Mr. Miranda said the possibility of doing some motion pleadings to clarify. But as I understand it, in the last evidentiary hearing, the commission ruled that the email exchange between Cimarex and Colgate satisfied negotiations, and therefore the existing order stays in place as an order subject to de novo review. Cimarex, as a party of record, has submitted its competing applications for the Crest wells in case numbers 22018 and 22019, whose submissions have been approved by the OCD. They are currently waiting to be reviewed for the proper forum, and I believe that is one of the remaining questions to be addressed, possibly by motion pleadings. And I apologize, I don't know the exact date set for the hearing on the merits, but I believe it was in June, if I'm not mistaken, but I could be corrected on that.
Ms. Davidson, can you confirm that it's still on the June docket? I think you're muted.
Yes, it's still on the June docket.
It is.
Yes.
Okay.
Yes, thank you, Madam Chair. That's all I have at this point.
Mr. Padilla?
Oh, I'm a little confused because I didn't realize that, I don't think that we have competing applications. We certainly haven't ever been noticed on that. The competing application that was filed by Cimarex was withdrawn for lack of notice. Our contention is going to be that the de novo hearing is simply based on the record before the the division. Therefore, competing applications are not applicable simply because they were inappropriately filed without notice. And I think EOG filed a motion to dismiss, and Cimarex withdrew their application. So I don't think they're there. And another thing is that based on the commission's ruling on the good faith issue, I don't know what there is to review before the commission. It seems to me that the sole issue was whether or not Colgate operating made a good faith effort to join Cimerex. As to Prosperity Bank, I don't know where they are. And I think, well, I think those issues were pretty clearly resolved by the commission's ruling on good faith. So maybe motions would be appropriate this time. And I think Mr. Melander had tried to avoid motions battle here, but I don't see how we can not have motions to limit or have the what really is before the commission.
Mr. Savage, do you have any response to that?
Yeah, I believe this is a very complicated case. Cimerex is a party of record in the underlying case. It's Cimerex understanding that the commission has established precedent and policy and some prior cases, in particular case numbers 21277 and 21278, that a pooling order can be challenged in a de novo proceeding by new pooling applications submitted by a party of record after the division has heard the original applicant's case and has issued a pooling order in the applicant's favor. The applications that we submitted, EOG, we did dismiss a first set of applications based on EOG's motion, but then we applied for new applications and we provided notice for those. So those applications are in the wings in a holding pattern. Cimerex respectfully asked the commission to exercise the same broad authority to allow a hearing of these competing applications as it did for the competing applications in its prior cases. It is clear from established precedent and policy that the prevention of waste and protection of correlative rights is paramount in the proceedings before the commission and take priority over any risk to the security or the potential finality of an order issued by the division until the division and commission have had the opportunity to complete their two-tiered review process of all applications submitted by the parties of record, and until the commission makes its final decision regarding waste and correlative rights. Cimerex is merely asking that its opportunity and the opportunity for the commission to prevent waste not be denied at this point.
Okay, Mr. Padilla, any response from you? And then I think we can move forward.
Oh, I think I've said made my points.
Okay, so it looks like at this point, we're still on for June. I'm expecting there might be some motions out of both of you prior to that date that can be decided on at the June hearing. Is there any, or is June still the expected date, or are we looking to have to continue this again? I think we've continued it multiple times and would like to sort of get a set schedule.
Madam Chairman, discerning Padilla, I think if we file motions, there'll be a period of at least maybe a month and a half. We may have to continue these cases, but I think as we hone in on the issues raised by the motions, then at that time we may decide or jointly decide that we need to move the cases down the line.
Okay. All right. Well, that's helpful, I think. Commissioners, do you have any questions for either Mr. Savage or Mr. Padilla as to where we are on the next piece of this case?
Madam Chair, I do not. I think the motions will be helpful. We have June meetings, June 9th, so that's about 7 weeks. I think that should give us plenty of time to have motions prepared and for us to go over them. Thanks.
Dr. Impoma? Any
Yeah, I
questions?
do. No, I do support the same thought from Commissioner Bloom.
Okay. All right. Thank you, Mr. Savage and Mr. Padilla. With that, let's move on to the second half of number 5, which was adoption of a final order in case number 21629. Commissioners, have you reviewed the final order, and is there a motion to adopt it?
Yes, Madam Chair, I was able to review the final order and I would move to adopt it.
Is there a second?
Madam Chair, I do second.
Thank you. Mr. Krankamp, would you please do a roll call vote on the order?
Yes, Madam Chair. On the motion, Chair Sandoval,
Approved.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Madam Chair, the vote is unanimous.
Thank you. Ms. Davidson, would you please circulate the final order with the commissioners so we can get that signed and finalized today?
Right. I will do that.
Thank you.
And Madam Chair, if you permit me, do we need to establish dates by which motions would be due? I know also in some cases we have limited the length of those. And I don't know if we'll allow replies to motions either.
For the June case,
Yes.
I would be fine with that. If we want to put some structure around it. Let me look at the calendar again. So if we're looking, at least 4 weeks out, that would put motions due by at least the 12th of May, or we could push it back to the 5th. We could do motions by the 5th, replies by the 19th. And then that gives us, 3 weeks, I guess, to review everything. Mr. Savage and Mr. Padilla, do you have any concerns with that?
No. Madam Chairman, I'm trying to figure out, May 5th would be the deadline for filing motions.
Yes.
And then response would be due on the 12th.
Yes.
And
No, 19th. 19th.
on the 19th. And then will there be an opportunity to file replies, or as Commissioner Bloom said, you may limit that just to simply a motion and a response?
I think we do have time for replies. Let's see. So if we do the response on the 19th, we could do replies by the 30th. Or actually maybe the 27th.
Madam Chair, I feel that just motions and an initial response would be sufficient. And we limit them to 10 pages, I'm sorry.
I was about to say, I'm okay with doing reply, like motion responses and then allowing a reply. If we limit the page numbers on them. We don't need a thesis, I think.
I'm sure I'm fine with that if that's how you'd like to proceed.
Okay, 5 pages, 8 pages, 10. I think of the core documents, if you have any sort of exhibits, that would be extra. We can split the middle and say 7. 7. Okay. All right. Ms. Davidson, do you happen to have a case number for this in June? So I can motion it with a case number. Or if Mr. Savage or Padilla has it offhand.
Is it still de novo case 21744?
I'm not sure.
I believe that's where we're headed.
I think so, but I just want to confirm.
Commissioner Bloom, this is Darren Savage. I'm looking at the agenda. It looks like it is, the de novo case is 21744 on that.
Okay. Okay, great. So in de novo case number 21744, we will set a motions deadline of the 5th. Responses are due by the 19th. Replies are due, I'm sorry, why don't I give you months for these days? Motions are due by May 5th. Responses are due by May 19th, and replies are due by May 27th. At the end of day for all of those, and for all of the motions, responses, and replies, a maximum of 7 pages, not including any attachments or exhibits.
Madam Chair, a quick question, though, if I may. So in the final order, I think we made a decision on the Cermex application for hearing de novo. So is that the same thing that we're going to talk about? For the same number?
We did. Hold on. Let me pull up the final order.
Okay.
So I believe that we got an old copy up.
Madam Chair, if
So
you'll
there were
permit
six-
me.
Oh, go ahead.
Yeah. My understanding in paragraph 111, we say that Cimerex application in this matter for a hearing de novo before OCC is denied.
It's denied.
Related back to the question of whether proper notice was given, but that this was a bifurcation of the case and that there's still a de novo hearing potentially pending on the other side.
Yes, so there's 2 pieces to this case. We bifurcated it back, 6-8 months ago. So there was the case for the good faith notice effort that we decided on, which is this order. And then there's this additional de novo case. So they're two separate issues.
Thank you, Madam Chair.
Just for clarity's sake, I'll remake the motion. Okay, for de novo case number 21744. I actually don't know if that's the right case number. I'm sorry.
Prior
This-
case was 21629.
Okay. We'll get there. Nova case number 21744. Motions are due May 5th. Responses are due by the 19th of May. Replies are due by the 27th. All of these are limited to 7 pages of the core response or reply or motion, and does not include attachments and or exhibits. Is there a second to that motion?
Madam Chair, I second.
Mr. Kryenkamp, would you do a roll call vote, please?
Yes, Madam Chair. On the motion, Chair Sandoval,
Approve.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Madam Chair, the vote was unanimous.
All right, thank you. We will hear from you soon then, Mr. Savage and Mr. Padilla.
Thank you, Madam Chair. Thank you, Commissioners.
Thank you very much.
All right, next item on the agenda is agenda item number 6, update on case number 21872, which was an application of Titus for approval of production allocation. I believe the division will be providing us an update on the status of the MOU in that case. Is there somebody available from the division?
Madam Chair, this is Jesse Tremaine for the Oil Conservation Division. Our General Counsel, Mr. Fuge, is available for this update. I just want to point out, as we're addressing item number 6, that the update, I think, is going to be directly relevant to item number 7 as well. So however the commission wants to handle that, I think it might be, if you want to open both cases at the same time, however that needs to proceed, but I think it would be beneficial to provide the update once.
Mr. Kryenkamp, are we able to sort of merge 6 and 7 and start sort of case number 22473 with the update from the division on 21872?
Well, yes, Madam Chair, from an Open Meetings Act standpoint, yes, you can definitely do that. You're limited to taking action, to those items listed on the agenda, but for the sake of efficiency, if you wanted to take up the one and then return to the other item, you certainly could do that.
Okay. Let's do that then. Let's see. Shaheen, are you here?
Yes, I am, Madam Chair and Commissioners. Sharon Shaheen on behalf of Titus Oil and Gas Production, LLC. I also
right.
have, I'm sorry, I also have my client, Walt Jones is available. He's viewing from the public link. So if you have any questions for him, I think you'll need to allow him to present.
Okay. I just moved him into a panelist position. To start, before we go into opening statements in case number 22473, let's provide an update from the division on 21872.
Madam Chair, I apologize. This is Dana Hardy with Hinkle Shaner.
Go
And I
ahead.
had also entered an appearance in this case, in both of these cases on behalf of Pegasus, Fortis Minerals, and Santa Elena Minerals.
Okay, good morning. Are you okay with merging these two as well?
Yes, absolutely.
Okay, great.
Thank you.
All right. I think Mr. Fuge, you're up to provide an update in 21872.
Good morning, Madam Chair, Commissioners. Consistent with the Commission's order, I'm here to provide an update on work with and on behalf of OCD negotiating an MOU with the Texas Railroad Commission to govern the development of the proposed interstate oil and gas production wells. Since my prior update, I can report that the Oil and Gas Conservation Division, my office, received a copy of a draft MOU prepared by the Railroad Commission. We have since, marked that up and prepared a red line, which was returned to the Railroad Commission on April 8th. And we currently have a meeting on the calendar to talk with Railroad Commission leadership and legal counsel on April 20th to walk through our red lines and see what areas of remaining differences there are, or if the current draft of the MOU is largely acceptable to the parties. That meeting date is contingent upon Texas Railroad Commission's counsel and leadership being able to review the sufficiently review the red lines provided.
Thank you, Mr. Fuge. Are there any questions from the commissioners regarding the status?
No, Madam Chair, not at this time. Thank you.
No, Madam Chair.
Okay. Mr. Fuge, will you be available for questions as this later, I guess, as this relates to 22473?
Yes, Madam Chair.
Okay. All right. Thank you. So, all right, let's move into opening statements for case number 22473. Ms. Shaheen, would you like to start?
Yes, thank you, Madam Chair. This case, this application is very similar to the case, to the application that was filed in the previous case, number 21872. A brief history might be helpful. Titus on its development plan for these interstate wells, of which there are numerous wells, in September of 2020. In November of 2020, Titus began conferring with the Oil Conservation Division, and at which time it was instructed to request approval for allocation of production. At about the same time, Titus began conferring with the Railroad Commission. In January of 2021, Titus began conferring with the State Land Office and the BLM. 1 year ago, they filed the application in the case in which we just had the update, seeking approval of production allocation for the El Campeon FedCom 404H interstate well. The matter was heard by the division. The case was then referred to the commission in September, and on September 28th, the commission issued order number R-21831-A approving the application, but providing that Titus could not commence production until an MOU had been entered. Unfortunately, Titus determined that it was not economically feasible to wait until an MOU had been reached, and they went ahead and drilled the El Campeon 404H fully within New Mexico. Nonetheless, they have a number of wells that they still intend to drill across the interstate line, including the well that is the subject of this application, the El Campeon FedCom 204H. So this, turning to the exhibit package, I'm not sure if you all have the exhibit package, but it includes the written direct testimony of landman Walter Jones, who is available to answer any questions. I can walk briefly through his written testimony with him or without him, or he can just stand for any questions that the commissioners may have we don't want to take up a whole lot of time if it's unnecessary. But it's about a 5 or 6 page document with written testimony explaining where this well will be located. It will be located in the exact same spacing unit. The difference is that it will be a slightly different location, and it will be to the Bone Spring Formation instead of the Wolf Camp Formation. We have a couple of exhibits. One is the C-102 for the newly proposed interstate well, the 204H, and the second is the notice letter that went out to all of the parties who have interest in acreage surrounding the spacing unit, and that was who we were instructed to notice previously. My affidavit of notice is also part of that notice letter, and we have the spreadsheet reflecting who received notice, and miracle of miracles, everyone in this case received certified mail of the notice letter and application. With that, I'll proceed as you prefer. As I noted, Mr. Jones is available for any questions.
Okay, let's provide the other parties an opportunity for an opening statement in this, and then we can come back to you for, I would be, and I'll let the other commissioners weigh in, but I am fine if you want to provide kind of a brief summary of the testimony and then provide an opportunity for questions to Mr. Jones. Commissioners, do you either agree or have a difference of opinion?
Madam Chair, I agree with that. Thank you.
I agree with that too, Madam Chair.
Okay. Great. Would the division like to make any opening statements?
Madam Chair, as consistent with our pre-hearing statement, the division's position in this case is, I think, very straightforward. We're asking the division to take notice of the testimony and exhibits in case 21872 because for purposes of the MOU and interstate development, the division sees this case as essentially indistinguishable from that other matter. We have the same exact concerns, and we'd take no position on the technical components of the proposal and do not object to it on any of those grounds, and ask the commission if it determines that it's appropriate to approve this application by Titus, that it condition the application approval and issue an order consistent with the order issued in 21872. Thank you.
Thank you. Ms. Hardy, do you have any opening statements?
Yes, thank you, Madam Chair. I'll be very brief. Pegasus, Fortis, and Santa Elena, which I'll refer to collectively as Pegasus, support the application of Titus. They own 434 net royalty acres in sections 29, 30, 31, and 32 in New Mexico, and section 25 in Texas. And they would benefit, all the royalty owners and interests would benefit greatly from the drilling of Titus's wells. And approving Titus's application and allowing the wells to be drilled across the border would prevent waste and protect correlative rights, as portions of Pegasus acreage in Texas would be stranded if the applications are denied or if Titus doesn't proceed to drill its wells as they have planned. So we would ask that the application be approved. And that's it. Thank you.
Thank you. Am I recalling that there was the state land office had made an entry of appearance on this?
Madam Chair, they made an entry. They entered an appearance in case number 21872. We reached an agreement, a stipulated agreement with respect to a draft MOU. And to my knowledge, the state land office did not enter an appearance in this particular case, which is case number 22473.
Okay, great. Thank you for that. All right, Ms. Shaheen, would you like to proceed with your first witness?
Yes, Mr. Jones, are you available to be sworn in?
Uh-oh, let me flip my camera here.
Yeah, we're looking at your wall.
I may have to go to the other side of the table here. Oh, that's not it.
Now it was your upside down wall.
There I
There you
am.
go.
I apologize.
No problem. Ms. McFarland, would you please swear in the witness?
Is it Mr. Jones? I'm sorry, I forgot the name already.
Yes, it's Walter Jones.
Thank you. Mr. Jones, this is Mary McFarland, your court reporter. Would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
All right,
Good morning.
thank you. Ms. Shaheen, go ahead.
Good morning, Mr. Jones.
Good morning.
You have your written direct testimony in front of you just to refresh your recollection.
I do.
And you are a landman with Titus, is that correct?
That's correct.
And what is your title?
I'm the Vice President of Land at Titus.
And as the Vice President of Land at Titus, you're familiar with this application, is that correct?
Yes, that's correct.
And you're also familiar with the previous application filed in case number 21872, is that right?
Yes,
And you've previously testified before both the commission and the division, is that also correct?
that's correct.
And your credentials as a petroleum landman have been accepted as a matter of record, correct?
Correct. Yes.
And in this case, can you describe, compare the well proposed in this case, 22473 with the well that was proposed in case number 21872? Just compare those two wells for the commission.
Yes, it's the same proration unit as the previously proposed well. The only difference is that this is targeting a Bone Spring or the Bone Spring formation, whereas the former or previous well was a Wolfcamp well. And there's also a slight difference in surface location just because it's different wells.
And who are the working interest owners in the proposed spacing unit?
It would be 100% Titus in the New Mexico portion, and then Oxy in the Texas portion.
And do you have an agreement with Oxy with respect to this particular well?
We do. We have an agreement to enter into a joint operating agreement.
And does the completed interval comply with the statewide setback requirements for oil wells under New Mexico regulations?
Yes.
And what about the first and last take points? How do those comply with New Mexico regulations?
Yes, I believe so.
And well, with respect to the last take point, where would that last take point exist in New Mexico?
That would be at the state line. So be 0 feet from the south line of section 32.
And does Titus anticipate requesting approval of a non-standard location under that circumstance?
If the commission or division would like us to, then yes.
And the last take point, as we've discussed, is located in Texas. Is that correct?
That's correct.
And what leases comprise the spacing unit?
There's a federal lease in section 31, I'm sorry, section 29, a state lease in section 32, and then a few fee leases in the Texas section 25.
So would the state lease benefit from taking this take point to the interstate line between New Mexico and Texas?
Yes, it's going to, there'll be more treated or completed lateral on New Mexico lands.
So you'll recover more minerals as a result?
That's correct.
And previously, the division approved the request for production, approved the production allocation proposed in case number 21872. Does Titus propose the same type of production allocation in this case as well?
Yes, we did.
And can you summarize what you've proposed with respect to allocating?
Yeah, so the allocation would be based on surface acreage that makes up the proration unit. So each tract would be allocated just in accordance with how much of the entire proration unit it makes up.
With respect to permitting from Texas, what do you anticipate?
The guidance we've received from Texas is that this would be treated this well would be treated in a similar fashion as the previously proposed well. We don't anticipate any issues with the permitting of this well. We have not permitted it yet just because we're waiting on the memorandum of understanding.
And the Railroad Commission permitted the previous well in case number 21872, is that right?
That's correct.
With respect to API numbers, how does Titus anticipate dealing with reporting in New Mexico and reporting in Texas?
We anticipate that each portion of the well will have its own unique API. So the portion in New Mexico will have a New Mexico API identifier, and the portion in Texas will have a Texas API. And that will really allow us to effectively proportion out or divide out any reporting, any sort of production, any allocation can be made in accordance with the APIs.
Is if the well was only drilled in New Mexico, would there be stranded acreage in Texas?
Yes, it's very likely.
And can you explain, and I can direct you to the paragraph in your testimony, paragraph 25, explain the previous development in Texas and why there is a possibility of stranding acreage if Titus cannot drill across the state line?
Yes, there are already established developments to the south of this acreage of the section 20, the section in Texas already has established development. So if another operator were to come in, it's very likely they would continue that established development pattern, which would strand this section for future development.
And scrolling down in the exhibit package to exhibit 1, I believe this is the C102 for the 204H, is that correct?
Yes, that's correct.
And this illustrates the entire spacing unit, including the acreage in New Mexico and the acreage in Texas that's proposed to be developed. Is that right?
That's correct.
And you've, Titus, noticed all of the mineral interest owners with acreage that is adjacent to the proposed spacing unit. Is that correct?
Yes.
Madam Chair, I have no further questions of the witness. I would pass him for any questions from the commissioners or other parties.
Thank you. Mr. Tremaine, do you have any questions for Mr. Jones?
I do not have any questions. Thank you.
Ms. Hardy?
I do not have any questions. Thank you.
Commissioners?
No questions, Madam Chair.
Dr. Impoma?
Madam Chair, no questions from my side.
I just have one question. Mr. Jones, are you familiar with order number R21831A, which was the order entered in case number 21872?
I probably would need a refresher. I may know or I could pull it up, but.
I guess, are you just basically familiar with what the requirements were from that case?
Yeah.
Are you comfortable with those same requirements on this proposed well?
Yes. Yeah.
Okay. That's my only question. Ms. Shaheen, do you have any redirect?
No, thank you, Madam Chair. I would just, if we're going to conclude our presentation, I would ask that the exhibits and Mr. Jones' written direct testimony be admitted into the record along with, as we noted in our pre-hearing statement and Mr. Tremaine requested, we ask that the exhibits and testimony from the previous case number 21872 be included as part of the record in this matter as well, and that the commission take this case under advisement.
Okay. Let me make sure I'd like to cite just want to make sure I'm going to cite this right. Is there any opposition from any of the parties on entering into the record direct testimony of landman Walter Jones, Titus Exhibit A, exhibits number 1 and 2, affidavit of notice Exhibit B, as well as the testimony and record from case number 21872?
No objection from OCD.
No objection from Pegasus, Titus, or Santa Elena.
Any questions or concerns from the commissioners?
No, Madam Chair.
No, Madam Chair.
All right. Exhibits and the record from 21872 is entered into the record in this case number. Oh man. 22473.
Thank you, Madam Chair, Commissioners.
Thank you. Can you, I think, let's not dismiss Mr. Jones yet, just in case we have any future questions. He can step down for now, but we're not, he's still sworn in. Any additional witnesses, Ms. Shaheen?
No, Madam Chair, just Mr. Jones today.
Okay. Mr. Tremaine, do you have any witnesses or testimony for today?
No witnesses or testimony, Madam Chair.
Okay. Would you just, I think for the record today, could you provide the commission with just a really high level brief overview of what the division's stance was in case number 21872?
Absolutely. In case 21872, as well as in this case, the division is concerned with, at a very high level, the appropriate management of New Mexico resources and potential conflicts that could arise due to some fairly significant differences in the regulatory structure between the state of New Mexico, the Oil Conservation Division, and the Railroad Commission. We talked about a number of issues in the prior hearing related to appropriate proration, oversight of downhole factors, wellbore integrity, site inspections, application, clarification as to proration or appropriate apportionment related to the Oil Conservation Division's waste rule, and clarity on concerns about clarity regarding how the two agencies are going to work together if there is some sort of transboundary issue, and highlighted the concern that OCD wanted to create a structure and agreement between the Railroad Commission and New Mexico that would be fair and appropriate for both agencies in both states' relative interests, regardless of the well location, whether that's in New Mexico or whether that exists in Texas. Similar to the previous case, this well is situated in New Mexico and accesses Texas minerals. And so there are some issues, immediate issues that OCD is concerned with regarding the waste rule, how the gas that is vented or flared is apportioned between New Mexico and Texas. So what portions of that need to be accounted to New Mexico, for instance. And I think that summarizes at a high level, but there are various issues, and I don't think I hit on this. We want to make sure that we have a structure in place so that OCD and Railroad Commission are not, creating a process on the fly if there's any kind of integrity issue or release, anything like that. Thank you.
Thank you, Mr. Tremaine. Do any of the parties have any questions for Mr. Tremaine? Ms. Shaheen?
No, Madam Chair, if you'd like, I could ask Mr. Jones to speak to the fact that this well is in New Mexico and that Titus agrees that it is subject to all New Mexico regulations with respect to this particular well. I'm happy to bring him back to talk about that if you like. It should be in his written direct testimony as well.
Okay, at this time, I don't think we need that, but thank you. Ms. Hardy, do you have any questions for Mr. Tremaine?
I do not. Thank you.
Okay. I think maybe because the update in case 21872 is applicable in this case 22473, maybe a process question, just real quick, Mr. Kreienkamp. If the parties, if I want to open up for an opportunity to either the parties or the commission to ask Mr. Fuge any questions on the status, do we need to swear him in?
I probably would recommend swearing him in, yes, as long as it's part of this hearing.
Okay. Ms. McFarland, would you swear Mr. Fuge in, please?
Yes, Mr. Fuge, would you raise your right hand, please? Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you.
Okay, thank you. So Mr. Fuge, you gave an update earlier on the status of the MOU. I just want to provide an opportunity to the parties to ask questions, and then the commissioners. Ms. Shaheen, do you have any questions for Mr. Fuge?
A couple. First, I was wondering, Mr. Fuge, could you identify any particular issues that have been raised by your communications with the Railroad Commission?
You know, at a high level, the initial draft MOU from the Railroad Commission was drafted to be specific to Titus's original proposal. And from the state of New Mexico's perspective, there's no reason to treat, you know, to deal with interstate wells on an MOU by MOU basis. We'd rather just have a standing MOU that covers all scenarios. And if you're going to have interstate production intervals and you're going to have a general MOU that allows for these types of development, it needs to address both the scenario where surface facilities are on the New Mexico side of the border and where surface facilities are on the Texas side of the border. And so that's the thrust of most of our red lines back to the Railroad Commission, so that this can just become an MOU addressing interstate wells and similarly situated proposals, regardless of where surface facilities are located.
So would it be fair to say that that Texas was looking at a very narrow MOU, whereas New Mexico wants a broader one that applies to all potential interstate wells?
Texas was looking at an exceedingly narrow well, Ms. Shaheen, in that it would not even cover the current application that you have pending. The new application that you have pending, it would just have covered the historical one. And from an administrative efficiency and other things like that, and just sort of operational management, it's not in the interest of the state of New Mexico to enter into a narrow one.
And is there any indication as to timing, as to when the states may reach an agreement on a draft or on a final draft MOU?
I can't speculate as to timing because there isn't sort of a mandatory deadline, driving frankly, a discretionary agreement on both sides. But as I indicated, we do have a meeting next week where hopefully we can sit down and, see what areas of open dispute there are. And there probably a better sense of timing, after that meeting occurs.
Thank you, Mr. Fuge. I appreciate you spending your time working on this project, as does Titus, and I'll pass the witness. Thank you.
Thank you. Ms. Hardy, do you have any questions?
I do not. Thank you, Madam Chair.
Okay. Commissioners, are there any questions?
No, Madam Chair.
No, Madam Chair.
Thank you. Mr. Tremaine, do you have any additional questions for Mr. Fuge or any redirect?
None. Thank you.
Okay. Thank you, Mr. Fuge. I think unless you just really want to stick around, you're free. You're free to go. Thank you for the update. Mr. Tremaine, do you have anything additional before I go to Ms. Hardy?
No, I do not, Madam Chair.
Thank you. Ms. Hardy, do you have any witnesses or wish to make any additional statements?
I do not. Thank you, Madam Chair.
All right, thanks. Ms. Shaheen, I will give you an opportunity to either recall any witnesses or do any additional statements before we go to closing statements.
I don't have anything additional. I just would once again ask that the application be approved and that the parties continue to move forward working on that MOU so that we can move forward with our development plans.
Commissioners, before we dismiss Mr. Jones, do you have any additional questions for Mr. Jones or Ms. Shaheen?
Madam Chair, no.
Madam Chair, no questions.
Okay. All right, Ms. Shaheen, do you have any closing statements in this case?
I'll just briefly state that Titus believes that its development plan to include interstate wells will protect correlative rights, prevent waste, and we ask that the commission and the division continue to help facilitate acquiring an MOU that would allow Titus to continue or to begin at this point drilling under this particular development plan. And with that, I ask the commission to take the case under advisement.
Thank you. Mr. Tremaine, do you have any closing statements?
Only very briefly, Madam Chair. I'll rest on the statements I've already made, but the division's perspective is that this development could and would be in the interest of both states and the operators once that MOU is in place, ensuring that the Railroad Commission and the OCD have a path forward already in place should any issues arise, and that based on what we've seen so far in the proposed language, I'll always be cautiously optimistic, but I think the division is optimistic that an MOU is certainly possible.
Thank you. Ms. Hardy, do you have any closing statements you wish to make?
Madam Chair, only that the Pegasus entities support Titus and request that the application be approved. Thank you.
All right, thank you. So the record for this application hearing is closed. In case number 22473. I think the commission will immediately deliberate so as to reach a final decision on the application. I would move that the meeting be closed pursuant to the administrative adjudicatory deliberations exception to the Open Meetings Act, Section 10-15-1 H3, to deliberate in case number 22473. Is there a second on that motion?
Madam Chair, I so second.
Mr. Krankamp, would you please do a roll call vote?
Yes, Madam Chair. So on the motion to enter into closed session, Chair Sandoval,
Approve.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Madam Chair, the vote was unanimous.
All right, the commission will now close the session and the record. So commissioners, I will send a separate meeting invite shortly, so watch for that and we can jump on a separate meeting. Same for you, Mr. Krankamp. I'll send that to you as well. Everybody else can stay on here. I'm cautiously optimistic that this is not going to take too long, but we will see. So I would say that everybody should plan to be back and check in at 11. I will provide everybody an update at 11, either if we are still deliberating or we might come back at 11 if we are done deliberating in this case. So on the chance that we are done deliberating in this case at 11, we can go ahead and start, after we complete that, we can go ahead and start agenda item number 8, which is de novo case number 22474. All right. So we will check back in with everybody at 11, and commissioners watch for that other meeting invite. Thanks.
Thank you.
Thank you.
Ms. McFarland, are you there?
Yes, I am. Thank you.
Okay. It looks like we've got Dr. Ampoma and Mr. Krankamp. I don't see Commissioner Bloom yet, so we'll give him a second.
All right. you all hear me?
Okay. Yep.
All right, thank you, Madam Chair.
All right. Well, let's get rolling again. It's 11:01 and we'll start back up. First off, is there a motion to come back into an open meeting from the closed session for deliberations, which is an exception to the Open Meetings Act, Section 10-15-1 H3. So I guess, is there a motion to come back into session?
Yes, Madam Chair, I so move to come back in from the deliberations around case 22473, the only thing we discussed during that deliberation.
Is there a second?
Madam Chair, I second.
Mr. Krankamp, would you please do a roll call vote?
Yes, Madam Chair, on the motion to return and to open session and affirm that what was discussed in closed session was limited to what was specified in the motion to close. Chair Sandoval,
Approve.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
All right. All right, so in case number 22473, I move, I would make a motion to basically add, conditions to this approval in a similar fashion to case number 21872, and adopt conditions numbers 19 through 30, excluding number 29, the required division update, since the division update is already required per case number 21872. So adopt the order conditions from order number R-21831A. In this case, because it is substantially similar to case number 22473, and the records and testimony of that case, 21872, were adopted in case 22473. Is there a second?
Madam Chair, I second.
Is there any discussion?
Madam Chair.
Dr.
No.
Ampoma? No.
No, Madam Chair.
I would just add that, due to substantial similarities between the case in 21872 and 22473, which we're discussing today, the commission sees that the order conditions should reflect and be similar to those in that case 21872, which is in order number R-21831-A. Again, with sort of that exception that, the division is already providing regular updates as is required under order number R-21831A. Is there I'm sorry, Mr. Krankamp, would you please do a roll call vote?
Yes, Madam Chair. So on the motion, case number 2247, Chair Sandoval,
Approved.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Madam Chair, the vote was unanimous.
Thank you. So this order will be drafted and circulated to the commission for review prior to the next hearing. And then we will vote on a final order at our next regularly scheduled OCC on May 12th. All right, thank you, Ms. Shaheen. And Mr. Tremaine and Ms. Hardy.
Thank you, commissioners.
Thank you.
All right, next up is agenda item number 8, de novo case number 22474. So we have the parties for that case.
Yes, Madam Chair, Dana Hardy for COG Operating.
And this is Jesse Tremaine for the Oil Conservation Division.
All right, are there any other parties? All right, well, let's get started on this one. Ms. Hardy, would you like to make an opening statement?
Yes, I would, Madam Chair.
Please go ahead.
Thank you. In this case, COG seeks an order pooling uncommitted interest in the Wolfbone Pool underlying an approximately 960-acre standard horizontal spacing unit and seeks to dedicate the unit to 6 wells. Each well is approximately 1.5 miles in length and runs from south to north. All of the wells are at orthodox locations within the 960-acre unit. As a result, they comply with the division's 330-foot setback requirement and will not impact the tracts that surround the unit. Collectively, the wells penetrate every tract of the unit. 3 of the wells are proximity tract wells, which means that they are within 330 feet of the internal quarter-quarter section lines and incorporate the adjacent tracts. COG's testimony will show that its development plan is the best way to efficiently develop the acreage and that the plan will best prevent waste and protect correlative rights. There was no opposition to COG's application at the division. The working interest owners include multiple experienced operators, and none entered an appearance or expressed any concern regarding the unit. 2 individual interest owners entered an appearance but did not object. The case was presented by affidavit and no questions were raised at the division level regarding the application. On December 7th, 2021, the division issued order number R21930, which rejected the application because the unit is 960 acres and includes 3 proximity tract wells instead of 1. The division's order relied on Rule 19.15.16.15b, which I will just refer to as the proximity well rule, for the proposition that a standard horizontal spacing unit can only include 1 proximity tract well. And based on that determination, the division concluded that the unit is non-standard and requires notice to interest owners in the surrounding tracts. The division's decision should be reversed and COG's application should be approved. COG's proposal will best protect correlative rights and prevent waste. COG's landman will explain that the proposed development will not impact the surrounding tracts and that notifying interest owners in those tracts would not prevent waste or protect correlative rights. COG's geologist will explain that geology in the area supports COG's proposal. And finally, COG's engineer will demonstrate that the proposed plan will most efficiently produce reserves underlying the acreage. He will also explain that an alternative development plan that would require breaking this proposed unit into 2 separate spacing units would result in surface waste, environmental waste, and economic waste. The division's narrow construction of the proximity well rule is inconsistent with the Oil and Gas Act's fundamental requirement that the division prevent waste and protect correlative rights. Under New Mexico law, statutes and rules must be construed collectively to effectuate their purpose and avoid an absurd result. The division's narrow interpretation of the rule is inconsistent with the Act because it does not prevent waste or protect correlative rights. Rather, as COG's witnesses will explain, it results in waste and has the opposite effect. It does not protect correlative rights. The division's determination that COG must provide notification of a non-standard spacing unit and attain approval of such a unit does not make sense here because COG's unit does not impact the surrounding tracks. The division's narrow interpretation of the rule is also inconsistent with the rule's purpose. The rule was adopted to modernize development and allow operators to choose the best way to develop their acreage consistent with technological advances. The division's interpretation is inconsistent with that objective. In addition, neither the division's rules nor the Oil and Gas Act have ever been construed to only allow one well per spacing unit. The division relies on the fact that the rule refers to the well and a well, but that is not how the rules have been applied. It is standard practice for operators to include multiple horizontal wells in a spacing unit. The division also relies on section 70-2-17 of the Act, which states that it may establish a proration unit for each pool that is drained by one well. But here we are not talking about establishing a proration unit for a pool, and a proration unit is not the same as a spacing unit. The horizontal well rule expressly recognizes the difference and applies to spacing units. Today, with multi-pad and multi-well drilling, an interpretation of the Act and the rules that would only allow one well in a spacing unit, which is the logical result of the division's order, would not make sense and it would result in waste. And finally, the division has previously approved spacing units that incorporate proximity tracks from more than one well. In order number R-21089, the division approved a 1280-acre Bone Spring spacing unit that included 3 proximity tract wells, and those were COG's Admiral wells. And in order number 21055, the division approved a 900-acre spacing unit with 2 proximity wells, and that order related to COG's tinfoil wells. So in conclusion, COG's evidence will demonstrate that the division's decision should be reversed and that its application should be approved. Thank you.
Just one quick question, Ms. Hardy. Can you restate those 2 order numbers again?
Yes. R-21089 and R-21055.
Thank you.
Thank you.
Mr. Tremaine, would you like to make an opening statement?
I would. Thank you, Madam Chair. Primarily, the division is going to rely on the legal argument laid out in our pre-hearing statement. And this is, I think, a very straightforward legal argument. The statutory authority for proration and spacing units, the OCD interprets as being limited to an area which can be developed, produced, and efficiently drained by one well. In response to the distinction between a proration and spacing unit, I think that there is not judicial guidance on this point. They are different concepts, but for the purposes of statutory interpretation and under the Oil and Gas Act, those terms are used interchangeably. So for instance, in 70-2-18C, the Act refers to proration or spacing units within the context of defining the division's and the Commission's authority to define non-standard spacing units. So for the purposes of this analysis, I think that those terms should be treated as analogous, and that the division's interpretation of 70-2-17 should control. The OCD's concern with the application does not focus on any of the technical aspects of the application or COG's argument related to efficiency or, the most productive way to produce this particular acreage that's been referenced, 960 acres. It's based solely on OCD's concern with the recognizing the extent of the division's authority under the enabling statute. And I think that the problem here with COG's argument, while generally I would not dispute the rules of statutory interpretation and construction cited by Ms. Hardy, their argument focuses on interpretation of the rule, but overlooks the defining section of statute. So we're not talking about an absurd result here resulting from OCD's interpretation of just the rule. We're talking about the express intent of the legislature in defining that proration unit and the way the legislature treated proration and spacing units when it updated the statute last. So we're talking about the distinction between a general provision of the statute, which Ms. Hardy relies upon, in talking about prevention of waste and protection of correlative rights. Those are extremely important under the statute, and OCD does not dispute that, but that is a general provision under which OCD has a greater deal of discretion. That conflicts in this case with the very specific provision of the statute, which defines that proration unit and spacing unit as the area that can be produced and drained efficiently by one well. The prior order, in regards to the prior order orders referenced by COG, I think that this is an inappropriate focus. So the argument there essentially boils down to one of precedential value. And the appropriate focus should be here on whether or not the division has the statutory authority to define a horizontal spacing unit beyond the extent of its authority under the statute and the rule. And so if that is the determination, then COG's argument by extension asks this commission to view the prior orders as having precedential value overruling the specific language of the rule and the statute. That's not appropriate, an appropriate outcome in this case. Also, I want to point out that COG's argument here, I think, really just boils down to COG's belief that their development plan is the most effective for this area. Respectfully, I just think that that conflicts with the language of the statute. And if COG has a policy concern or argument related to the definition of those spacing units, then that needs to appropriately be made to the legislature. This is not the venue to try and interpret the Oil and Gas Act outside or beyond that specific language. I also want to just generally disagree completely with COG's statement regarding the historical interpretation of spacing units. I think that it's established that historically, aside from the potentially the referenced orders, that spacing units have always been treated as being defined or held by one well. There may be more than one well within a spacing unit, and those wells are attached to that spacing unit, but the well has a spacing unit has always been defined by the extent of the single well's lateral. So I think that this really all boils down to the commission needs to review and analyze this according to the appropriate provision of the Oil and Gas Act, which is the very specific language that applies here, rather than the general language. And I would reserve, at this time, I don't take any position regarding the technical aspects of the application. I don't have any objection to COG's exhibits, but I would reserve the right for any cross-examination if the commission is going to hear the technical aspects of the case. Thank you.
Thank you, Mr. Tremaine. Ms. Hardy, can you rerun through your list of witnesses, please?
Yes, Madam Chair. Our landman, Matt Sullivan, is prepared to testify, and then our geologist, Ira Bradford, and our engineer, Eric Angelos. And I don't think, oh, I apologize.
Oh, I was just going to make them panelists.
I believe they're all in one room.
Oh, okay. I see individual names. So I got Eric Angelos and Ira Bradford. Who was the third? Sorry, Matt Solomon?
Matt Solomon, correct.
Okay.
I see them appearing.
Great. Just before we go into the case, are you planning to present evidence and witnesses on behalf of the technical case, or some of the regulatory issues, or both?
It's both, I believe, Madam Chair.
Okay. You know, generally it sounds like the issues here are somewhat limited to some of the regulatory issues, but as the technical case dovetails into that, I think it's appropriate.
Thank you.
All right, would you like to call your first witness?
Yes, thank you, Madam Chair. COG calls Matt Solomon as our first witness.
Miss McFarland, would you please swear him in?
Yeah, sorry, I was having trouble unmuting.
You're fine.
Mr. Solomon, would you raise your right hand, please? Where is he? Do you guys see him? I don't see him.
There he is.
He's raising his hand.
Okay. Okay. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth? Thank you.
I do.
Thank you.
Can you please state your full name for the record? Oh, I'm sorry.
I'm sorry, I just said go ahead.
Okay, thank you.
Yes, my name is Matthew Solomon.
And on whose behalf are you testifying and in what capacity?
I'm testifying in the capacity of a staff land negotiator for COG Operating LLC.
Can you please briefly summarize your education and professional qualifications?
Sure. I graduated from San Jose State with a degree in broadcast journalism. Thereafter, I got a law degree from Oklahoma City University. After law school, I've now worked a total of 15 years in the industry, 3 as a landman for Chesapeake, developing urban units in the Barnett Shale, then 5 years with Hess Corporation, developing units in the Bakken and then Utica. And then the last part of my career has been with Concho/Conoco, working in this area of southeast New Mexico.
Have you previously testified before the New Mexico Oil Conservation Commission?
I have.
Were your qualifications as an expert in petroleum land matters accepted?
They were.
Madam Chair, I request that Mr. Solomon be qualified as an expert in petroleum land matters.
Mr. Tremaine, do you have any objections?
No objection.
Commissioners, do you have any questions or objections for the witness?
Madam Chair.
Sorry, Dr. Impoma?
No, Madam Chair.
Okay, the witness is certified as an expert. You can go ahead and continue.
Thank you. Mr. Solomon, can you please summarize COG's request in this case?
Yes, we asked for a 960-acre unit to develop the Wolfbone pool. That unit was predicated on 3 proximity wells, and it was denied.
Has COG previously obtained approval for spacing units that incorporate acreage from multiple proximity tract wells?
Yes, 2 instances I can think of.
In which instances are those?
Well, the first was for our Admiral unit. That was approved in order number R21089. That was a 1,280 acre unit developing the Bone Spring, and that was predicated on 3 proximity wells. The second instance was by authority of order number 21055. Therein, that was a 900 acre unit developing the Bone Spring. That was our tinfoil unit, and that was predicated upon 2 proximity wells.
Madam Chair, I request that the commission take administrative notice of orders number R21089 and R21055.
Any objections, Mr. Tremaine?
No.
Any questions or objections from the commission?
Madam Chair. No, Madam Chair.
Okay. The commission will take administrative notice of orders R21089 and R21055.
Thank you. Mr. Solomon, do you have a document in front of you that's marked as COG Exhibit 1?
I do.
Can you please identify that document?
Yes, this was the order in response to our application, order number R21930, which denied our application for a 960 acre spacing unit to develop the Wolf Bone predicated on 3 proximity wells.
And is that the order that COG is asking the commission to reverse?
It is.
What is your understanding of the reason that the division rejected COG's application?
My understanding is that a unit cannot be held together by more than 1 proximity well. So if you're asking for more than 1 proximity well, it violates the rules.
Mr. Solomon, can you please generally identify COG exhibits 2 through 10?
Yeah, these were the exhibits that I submitted when this case was originally heard on November 4th, 2021.
Can you please identify COG exhibit 2?
Sure, that is my self-affirmed affidavit, and everything that was testified to in this affidavit is still true and correct today.
Can you please identify COG exhibit 3?
Yes, COG exhibit number 3. This was of the application that we submitted, which was denied in the order.
How many wells does COG, oh, I'm sorry, were you finished?
No, go ahead.
Okay. How many wells does COG propose to include in its spacing unit?
6.
And which wells are the proximity tract wells?
That would be the 601H, the 602H, and the 603H.
Can you please identify COG exhibit 4?
Sure. Yeah, COG exhibit 4 are the C102 plats for the 6 wells that were to be developed in the unit. So 601H, 602H, 603H, 702H, 703H, and 704H.
Collectively, do the 6 wells penetrate every tract that is included in the spacing unit?
They do.
Are any of COG's proposed wells at unorthodox locations within the 960 acre spacing unit?
No, they are not. They are all further than 330 feet from an outside boundary.
Do all of the wells then meet the division setback requirements?
Yes.
Mr. Solomon, at this time, what is the percentage of COG's interest in the proposed spacing unit?
Well, it has increased a bit since the submittal of exhibit number 5. We now, having done a deal with OCC Y1, we now have approximately 93% of the working interest in the unit.
With respect to the proceedings before the division, can you please identify COG Exhibit 5?
COG exhibit. Yes, this was, this is a map of the unit showing the tracks that are, that the unit is composed of. And it also shows on subsequent pages after the map, the interest breakdown of the ownership in the overall unit and a breakdown on a tract level basis of the ownership within the tracts. Additionally, it shows on a pooling notification list those parties that got notification of the hearing, both working interest owners and people who held clouded unmarketable title.
Can you please identify COG Exhibit 6?
Sure. Yes, this is a copy of, it is two things. One is a copy of the well proposal that was sent to working interest owners along with accompanying AFEs. And then a separate letter, very similar to, but not exact, was sent to unleased mineral interest owners along with, again, accompanying AFEs for each of the 6 wells.
And does COG Exhibit 7 constitute your summary of communications with those parties?
It does, yeah, up to the point of the first hearing, yes, this is an accurate accounting of the communications.
Can you please identify COG Exhibit 8?
Yes, this was prepared on our behalf by Hinkle Shanner. It was a letter that was sent to all the parties who were due notice about the hearing that took place on November 4th, 2021.
And were hearing notices sent to all of the interested parties?
Yes.
And was notice also published?
It was. It was published, as can be seen in exhibit number 9. We have an affidavit of publication.
Did anyone contact you with objections to the application?
No.
Did anyone contact you with concerns about the size of the spacing unit?
No.
And did anyone contact you about the number of proximity wells included in the unit?
No.
Let's talk a little bit briefly about the hearing at the division. When did the division hear this case?
It was heard on November 4th, 2021.
And is COG seeking to pool working interests held by other operators?
We are.
And which operators are those?
Flip back to my list. That would be Marathon Oil Permian LLC, MRC Permian Company, Chief Capital, and that is it. BEXP1 has signed a JOA, and as you'll see, formerly Yates Industries LLC was listed, but it turns out that we now own that interest, so they are no longer have any dog in this.
In your experience, are those parties large and experienced operators and interest owners?
Absolutely.
And did any of them raise concerns regarding the proposed spacing unit?
No.
How many parties is COG seeking to pool for unmarketable title, approximately?
About 60.
And did any of those parties object to COG's application or the proposed spacing unit?
No,
Were any questions raised at the hearing regarding the proposed spacing unit?
no.
Can you please identify COG Exhibit 10?
Yeah, this is the pooling application checklist that we compiled in conformity with the rules.
And is that still a true and correct copy of the information regarding the wells that COG proposes to pool?
It is.
Mr. Solomon, I would like to share my screen and pull up COG Exhibit 11. So let me see if I can do that. Madam Chair, it looks like I don't have sharing enabled here.
Give me 2 seconds.
Sure.
While you're doing that, did the witness say 60 unmarketable?
60, correct.
Thank you.
Okay, let me give this a shot.
You should be able to now. Okay, it's coming up.
Okay. Can you all see that? Okay. Okay. Mr. Solomon, can you please identify that exhibit?
Sure. I composed this exhibit, and what it shows is the 960 that was proposed, that is within the red dashed border. And then you'll also see the 6 wells numbered from 1 to 6. The arrow going north indicating that they are spud from the south and drilled northward. And then around that, I have highlighted those owners and interests that would need to be notified if we went through the non-standard route of getting a unit.
And if I scroll down here, is this a list of the parties who would need to receive notice of a non-standard unit?
Correct.
And how did you identify those owners?
Well, we had to run title, and we had to run title on all of those tracks that you see highlighted in either pink, blue, or green. That was a total of 960 acres in eight different townships. Well, rather 8 separate sections.
Is it time consuming to run title on that number of tracks?
Very.
Can it be costly to run title on all of the tracks that surround a spacing unit like this?
Very.
And in this case, how many interest owners would you have to notify if you were notifying all of the surrounding tracks of a proposed non-standard spacing unit?
In this case, we would have to notify 6 working interest owners. Additionally, we would have to notify 5 unleased mineral owners that own in that green highlighted section you see. So a total of 11.
Are you familiar with other situations that would involve many more interest owners?
Oh, it could be hundreds. This 11 is fortuitous.
Based on your understanding from a land perspective, are any of the offset tracks affected by COG's application?
No, not at all, because as can be seen in the table that has the details for the flank wells, which are wells 1 and 6, not only are those wells not closer than 330 to the exterior boundaries, but in fact, they are 3 times as far off as what would need it to be. They are 1,000 feet off.
Does COG's application impact the correlative rights of the interest in the surrounding tracts?
Not at all.
Would providing notice to those parties result in potential harm to COG?
Absolutely. The problem with notifying these parties when you are not even within 330 feet of them, but again, in this case, 3 times as far, is they don't need to be protected. They don't need a shield here because we're not threatening their correlative rights. The problem is we're giving them a sword. And by giving them the opportunity to respond and object, they could, and I've seen it happen before, use that opportunity as leverage in completely unrelated negotiations.
And if an operator is required to seek approval of a non-standard spacing unit in a situation like this, would that create additional administrative burdens?
Absolutely.
And would those be burdens on both the operator and the division?
Yeah, yes, because it is a burden to collect and collate all this title information, to send out notices to the parties, and then of course the division has to process those.
And is it your opinion that that shouldn't be necessary in a situation like this where the wells aren't meeting the division setback requirements?
Yeah, there's no interest that is threatened here.
Is it your understanding that based on the division's order, COG would not have to notify owners in the surrounding tracts if its unit only included one proximity tract well?
That's correct.
But COG would have to notify owners in surrounding tracts if its unit includes more than one proximity tract well. Is that correct?
Correct.
From your perspective and in your experience as an expert in petroleum land matters, is there any difference between those two scenarios?
There's no substantive difference.
And why not?
Well, because in either case, the correlative rights by the outlying parties are in no way being threatened because the flank wells meet the setback requirements.
Mr. Solomon, in your opinion, would granting COG's application prevent waste, prevent the drilling of unnecessary wells, and protect correlative rights?
Absolutely.
Madam Chair, I move the admission of COG Exhibits 1 through 11.
Any objections, Mr. Tremaine?
No objection.
Commissioners, any questions?
Madam Chair.
No, Madam Chair.
Okay, we'll enter into the record COG Exhibits 1 through 11.
And Madam Chair, I have no further questions for Mr. Solomon, so I would tender him for questions from Mr. Tremaine or the commission.
Okay, Mr. Tremaine, do you have questions?
I just have a couple questions for Mr. Solomon. Thank you. Mr. Solomon, you had indicated that there were 2 prior instances in which the division had approved, I don't want to put words in your mouth, but analogous spacing units as standard. Is that correct?
That's correct. Yeah, our Admiral unit and in our tinfoil unit.
And the first one I think was referenced was order number R-21089. Is that correct? That's correct. And was that in OCD case number 20836?
That's correct.
Okay. That 1,280 acre unit, that application and order, that was identified in COG's pre-hearing statement. Is that correct?
That's correct.
Okay. And that application in case number 20836, that went to hearing as a compulsory pooling application, correct?
That is correct.
And would you agree with my statement that that application did not either identify the horizontal spacing unit as standard or non-standard?
Candidly, I can't recall, but I can get you that information.
Okay. And I have the same questions for the other one. I believe you referenced order R-21055. Is that correct?
That's correct.
That order was not identified in your pre-hearing statement. Is that correct?
I believe that it was identified in our pre-hearing statement.
Okay. And does that order relate to case number 20832?
It does.
Okay. And I have the same question from the previous. Is it fair to say that that application is for a compulsory pooling unit?
That's correct.
Okay. And that application identifies a spacing unit, but it does not identify the spacing unit as standard or non-standard, correct?
Again, I would have to review the entire order to get you a proper answer. I do not remember that offhand.
Okay. Mr. Solomon, would you agree that well, let me preface this. I've heard you make a number of statements now into the record about how time-consuming notices, the burden on COG, and this proposed development's potential impact on, or what you argue is a lack of impact, threatening correlative rights or impacting interest owners outside of the identified spacing unit. Would you agree that, those are policy statements, not legal argument?
I would not agree with either. I haven't had really time to reflect upon that, so I can't say yes or no to either proposition.
Would you agree that if the legislature of New Mexico states that a spacing unit over a certain size needs to be treated differently than a spacing unit identified by a single well, that the notice impact for COG would not override that legislative intent?
Madam Chair, Mr. Solomon, can you hold on one second? I apologize for interrupting. I'd like to object to that question because I think it calls for a legal interpretation. And Mr. Solomon is testifying about his experience and interpretation that the division has applied, but he's not offering legal opinions.
I'll withdraw the question. That was a poorly phrased question, Madam Chair.
Okay.
I'll reserve that for argument. No further questions for Mr. Solomon.
Thank you. Commissioners, do you have questions for Mr. Solomon?
No, Madam Chair.
Madam Chair, I do have a couple of questions. So, yeah, Mr. Solomon, like the OCD is saying, that it is a plain language, in the rule that this type of development needs to be treated differently, like non-standard. So if COG really wants to pursue this development, why can't they just follow the rule?
Well, again, I think what our attorneys laid out in the beginning is that they take issue with the interpretation of the rule. And again, that is a legal discussion, and I am not here in the capacity today of an attorney.
You made mention in the pre-hearing statement, and also in your testimony, you referenced to 2 orders by the division that they approved similar or close to, same type of development. But I want you to clarify on that, whether that particular application was standard or non-standard.
Again, I would have to review the application to see whether or not those particular terms were used, I'm happy to do so and respond with what I find.
Now, you made mention of the problems, some of the problems why you feel that you don't necessarily have to go through the non-standard. You talked about probably to give ammunition to the other owners, or more or less the other parties, to more or less prolong the process and all of that. Don't you feel that that requirement is also more or less to protect correlative rights?
It certainly is to protect correlative rights when, in fact, correlative rights are in jeopardy. In this case, I mean, it's been determined that if you are 330 feet or further away from an outside boundary, that correlative rights are not in jeopardy. And so, yes, if in fact correlative rights are in jeopardy, that notification is a proper remedy to protect correlative rights. Here, not only are we not 330 feet, closer than 330 feet, we're 1,000 feet off of the adjoining outer boundary. So in this particular instance, there is no jeopardy that warrants any sort of protective notice.
So now you made it clear that there is no problems, associated with that. Assuming, let's say, you still go ahead and give those notices out. And based on the experience of COG and also even the strong argument you are making now, don't you believe that if you go through the non-standard application process, you still have a strong case to prove that those units are not in jeopardy?
I think it is a case that we would certainly ultimately prevail on, but wherein the danger comes is if you give somebody who is not in jeopardy the ability to object, you then give them the ability to drag out and delay your operations, which in many cases is the leverage they are seeking to try to force you to do something on an unrelated deal. So the people who would object would, yes, ultimately know they would probably lose their objection, but their goal would not be to win. It would just be to delay and hold your feet to the fire on something else.
So then, will you agree also with OCD that they are trying to protect the law and not necessarily trying to refrain OCG from more or less proceeding with their development plan?
I'm sorry, can you say that again, sir?
I'm saying that based on what you just said, don't you believe that the OCD is trying to follow the law? They're just trying to follow the law, not necessarily that. Or do you think that there are parties that will object to your application if it is to be non-standard?
Well, yes, I certainly believe it's possible that if we were to go the non-standard route, parties would object. Sure. If it was in their interest to object, to force some other goal that was unrelated, sure, I've seen it.
Madam Chair, I do not have any further questions. Thank you.
Thank you. I just have a couple questions. So I think, have you read the division's pre-hearing statement?
I have not read it. I heard it and discussed by the council.
So in their pre-hearing statement, it says COG proposes the roughly 960 acre spacing unit as standard. However, the acreage would be held by more than one well, each situated within 330 feet of the respective quarter boundaries.
Correct.
So the way I'm reading that, or that reads to me, is that each well would be sort of within that required setback, or would be encroaching on that required setback, right?
It would be encroaching on the quarter setbacks and the middle, and the line which separates the east half from the west half.
So are you confirming that basically you're going over those 330-foot boundaries?
For the interior boundaries, yes, that is correct. But for the exterior boundaries, which pertain to the people we would have to notice, we are not within 330. We're 1,000 feet away.
Did you get non-standard location approvals for those?
I don't know that if we did or if we didn't.
If you're within the setback requirements, do you know if you're required to get non-standard location approvals for those wells?
Well, from my understanding is that we can do without non-standard setback requirements if in fact we are trying to propose as a standard unit. It's only when we are not proposing as a standard unit that we would have to get those non-standard, we would have to do the non-standard permitting and get the non-standard permission.
Okay. So it sounds, is COG's position that it would be hard and costly to have noticed all of those individuals, and that is why you treated it as a standard facing unit?
No, that is merely one concern. That was not the primary concern. The primary concern was that we wanted to have the efficiency of being able to have one less facility. If we were to do two separate units, because there's not an absolute equality of interest between the two units, that would make it extremely hard to get a 960 CA from the BLM, and which would allow us to do just one larger facility. But the main thrust of our argument is not the cost and time of notifying and the danger of notifying outside parties, but it is one element.
Okay, I don't have any further questions. Ms. Hardy, do you have any redirect for the witness?
Yes, I do have a couple, Madam Chair.
Okay, how long, I'm just looking at the time, how long do you expect it'll take?
Probably 5 minutes.
Okay, go ahead.
Okay, thank you. And I'll share my screen here again because I think that will help, I believe. Okay. Can you all see that?
Yeah.
Okay. So, Mr. Solomon, with respect to the non-standard versus standard locations, on your map here, Exhibit 11, is it correct that the wells as they are proposed in the 960-acre unit are all more than 330 feet from the boundaries of the unit?
That's correct.
Okay. So within the unit as you've proposed it, the wells are at standard orthodox locations and you wouldn't need an unorthodox location approval. Is that correct?
Correct.
It's only if the unit were broken out into multiple units that the locations would be unorthodox. Is that right?
Correct.
Okay. Thank you. And then I have here the application for COG's tinfoil wells. Can you see that?
I do.
And that is the application in case number 20832
Right.
that we've been discussing.
It says standard 968 unit in the opening paragraph.
Right. Okay, thank you. That's what I was going to ask. And then similarly, I've pulled up the application from COG's Admiral Wells in case number 20836. Is that what this document is?
Yes. And it's the same thing. In that opening paragraph, you'll see the passage on the fourth line down, a standard 1280 unit.
Thank you. And then this is the order in case number 22076. And does it say here that it is a standard unit?
Yes, again, in the opening paragraph, third line down, it says a unit is expected to be a standard horizontal spacing.
And then here I've pulled up the order in case number 20832, which is order number R21055. And does this order state that the application, the unit is as described in the application, correct?
Correct.
Okay, and the application described it as a standard unit. Is that right?
Correct.
Okay. And Mr. Solomon, with respect to the notice issue, I know you've mentioned the cost and sort of the burden of giving notice to parties in surrounding tracts, but is the primary issue really that you would be required to give notice to parties that don't have correlative rights that are impacted by the proposed unit?
That's precisely the most important issue.
Madam Chair, those are all of my questions for Mr. Solomon.
Okay, thank you. I think let's leave, I mean, you're dismissed for now, but you're still sworn in case we need to recall you later. Looking at time, why don't we take a break for lunch? I will just note that we will have to end by 4:30 today. So just timing, going over timing for everybody. Does coming back at 12:45 work for everybody?
Chair, if we could extend to 1 o'clock, that'd be great. I have a couple fires to put out.
Okay, all right, let's come back at 1 o'clock. I'll leave this up and running. So if you're gonna stay on, just mute yourself and turn off your video.
Thank you.
All right, thanks everybody. See you at 1.
Do you solemnly swear under penalty of law the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Thank you.
Can you please state your full name for the record?
Ira Andrew Bradford.
On whose behalf are you testifying and in what capacity?
I'm testifying for COG operating as a geoscientist.
Have you previously testified before the New Mexico Oil Conservation Commission?
No, I have not.
Can you please briefly summarize your education and professional qualifications?
Yes, ma'am. I graduated in 2003 from Allegheny College in Meadville, Pennsylvania, with a bachelor's of science in geology. I then went to New Mexico State University in Las Cruces and received my master's in geology in 2007. I've been employed in the oil and gas industry as a geoscientist since 2007, with COG operating since 2013, and in my capacity working as a geoscience supervisor for Lee County since 2017.
Madam Chair, I request that Mr. Bradford be qualified as an expert in geology.
Mr. Tremaine, any objections?
No objection.
Commissioners?
Objections?
No objections.
All right, Mr. Bradford is certified as an expert in geology.
Thank you. Mr. Bradford, can you identify the documents that have been marked as COG exhibits 12 through 16?
Yes, this is the self-affirmed statement of Brian Sitek, a COG geologist, for the exhibits that were for the original case.
And based on your review, are the statements contained in Mr. Sitek's affidavit true and correct?
Yes, they are.
And can you please identify COG Exhibit 13?
COG Exhibit 13 is our base map of the area showing the offset producing wells and our 6 proposed green eye shade wells on sections 1 and 12.
And can you please identify COG Exhibit 14?
Exhibit 14 is a structure map of the top of the Wolf Camp based off the offset well control, showing a slight up dip to the west in this area.
Can you please identify COG Exhibit 15?
COG Exhibit 15 is the base map again, showing the cross section A to A prime on the next, which is on the next exhibit.
Okay. And that's Exhibit 16?
Yes, Exhibit 16 is the cross section A to A prime, showing a gamma ray resistivity and neutron and density porosity curves, showing that the units across the targets for these wells in this area are correlative and uniform across this area.
Based on the information contained in these exhibits, is this area suitable for development with horizontal wells?
Yes, ma'am.
Is the orientation of the wells appropriate?
Yes.
Is the target interval continuous across the unit?
Yes.
Are there any faults, pinch outs, or geologic impediments to the proposed development?
No.
Will each tract contribute more or less equally to production?
Yes.
Is it your opinion that granting COG's application will best protect correlative rights, prevent waste, and prevent the drilling of unnecessary wells?
Yes, it is.
Madam Chair, I move the admission of COG Exhibits 12 through 16.
Any objection, Mr. Tremaine?
No objection.
Commissioners?
No objection.
No objection.
Okay, COG exhibits 12 through 16 are entered into the record.
Thank you. I have no further questions for Mr. Bradford and tender him for questioning by the commission or Mr. Tremaine.
Mr. Tremaine?
No questions.
Commissioners?
No questions, Madam Chair.
Madam Chair, quick one. Do we have the exhibits from OCG? It's COG. I know we have the one that has page 1 to 53. So I don't know if we have all the complete. And John, I was going to test you prior to this, but I don't know because I don't have it.
Is this with like, are you asking for the exhibit packet?
Yes, I do have 1 to 53. And I saw Hadi showing even up until like 120s, page 120s. So I don't know if we have that.
Oh, yeah, because I'm showing exhibit like 14 on page 123.
Yeah, I don't have that.
15.
Madam Chair,
Mhm.
I think I can clarify.
Okay.
Okay, so I think OCD did submit the division exhibits, but I think it was only maybe half of them because they had been submitted in 2 parts. But then in our exhibit packet, we included all of the division exhibits. We just renumbered them because we were going through them in this order with the witnesses. So all of the division exhibits are included in our exhibit packet in this case.
I pulled, I'm pretty sure I pulled this packet off of the case files.
Yeah.
Because it's pretty huge.
This one's 10 megabytes. Dr. Napoma, I'll see if I can email it to you here.
Okay, I appreciate that. Thank you.
I would email that through Mr. Cryenkamp.
Mm-hmm.
You can also go on the OCD case files. In the case file search, and then type in, I keep losing this case number.
22294.
22474.
Yeah, I don't have Mr. Kreinkamp's address, so no.
22474. Here, let's see which. And this is the. It's the second document listed on there from the left.
Yes, I have it now. Thank you.
I think these exhibits for me, like exhibit 15 starts on page 124. And maybe just generally, Ms. Hardy, when you are referring to exhibits, it might be helpful to share your screen.
Sure.
Okay.
I'd be happy to do that. Looks like my sharing got disabled here.
Oh, I am happy to give that back to you.
Thank you.
Okay, I think we were on commission questions. Dr. Impoma, did you have a question for the witness?
No, I couldn't review his testimony, so I cannot ask a question now.
Okay, well, I don't have any questions for this witness, but let's keep him on the record and we can recall him as necessary if there are further questions. Ms. Hardy, I'm assuming you don't have redirect since there were no questions that were asked.
That's correct. I do not.
Okay. Thank you, Mr. Bradford.
Thank you.
Would you like to call your next witness?
Yes, Madam Chair. Our next witness is Eric Angelos.
Ms. McFarland, would you please swear the witness in?
Certainly. Sir, would you raise your right hand, please? Do you solemnly swear, under penalty of law, the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
Yes, ma'am, I do.
Thank you.
Can you please state your full name for the record?
Eric Angelos.
On whose behalf are you testifying and in what capacity?
I'm testifying on behalf of COG Operating LLC in the capacity of Reservoir Engineering Supervisor.
Have you previously testified before the Oil Conservation Commission?
No, ma'am.
Can you please briefly summarize your education and qualifications?
Sure. I'm a graduate of New Mexico Tech in Socorro, New Mexico, with a Bachelor of Science in Petroleum and Natural Gas Engineering. I was previously employed by Contra Resources and currently employed by ConocoPhillips. Have over 8 years of experience, primarily focused within the Delaware Basin.
Madam Chair, I request that Mr. Angelos be qualified as an expert in reservoir engineering.
Mr. Tremaine, any questions or opposition?
No objection.
Commissioners?
No objection, Madam Chair.
No objection, Madam Chair.
Okay, Mr. Angelos is classified as an expert for the purposes of this hearing.
Thank you, Madam Chair. Mr. Angelos, are you familiar with COG's application in this case?
Yes, ma'am.
And have you reviewed the division's order rejecting COG's application?
Yes, ma'am, I have.
And what is your general understanding of the division's decision?
In general, the division has rejected COG's request to develop a 960-acre spacing unit using multiple proximity tract wells.
If COG is not authorized to develop its 960-acre unit, what are its alternatives?
I think there are two alternative options: either propose a non-standard spacing unit or break its unit out into multiple units.
If COG were to seek approval of a non-standard spacing unit, is there any way to know that the unit would be approved?
No, ma'am. There's an evident business risk. As parties can object, a hearing can be held. I think Mr. Solomon addressed these issues associated with the notice and approval of non-standard spacing units very well in his testimony.
If COG were to break its proposed unit out into multiple units, would there be negative implications for COG, interest owners, and the public?
Yes, ma'am.
Let me share my screen here. Can you see this, Mr. Angelos?
Yes, ma'am.
Okay. Let me shrink it down a little bit. And can you please identify this document?
Yes, ma'am. Exhibit 17 displays a surface use diagram for COG's proposed spacing unit in comparison to a multiple spacing unit scenario.
And did you prepare this exhibit?
Yes, ma'am. Someone under my direct supervision did.
And what does the exhibit show with respect to surface facilities?
As currently premised with the single spacing unit, a single pad and surface facilities are designed to service the entire project of 6 wells. This can be seen by the arrow denoting the single pad separation plan.
If COG is unable to develop the unit as it has proposed, what additional surface facilities would be required?
Right. Simply put, a duplicate version of the current facilities would be required, and that would be on the arrow denoted additional required pad.
How many additional acres would those additional facilities impact?
This would impact an additional 3.7 acres.
And what types of surface impacts result from more surface facilities?
So overall, this would be a 21% increase in surface use. That's really not including any sort of additional roads or flow lines that would be required as well.
And does the use of additional surface facilities have environmental impacts?
Yes, ma'am. The larger surface footprint would most certainly have repercussions from an environmental standpoint.
And what types of repercussions?
So in general, the duplicate facilities would double the number of GHG emission points and ultimately increase our exposure to fugitive emissions.
And can you explain what's shown on the exhibit with respect to the emissions points?
Yes, absolutely. So in general, the largest culprits within new facilities would be pneumatic devices, additional tanks, 8 in this scenario, and then certain combustion sources.
And would those additional emissions points potentially result in additional emissions?
Yes, ma'am.
And does having more surface facilities increase costs as well?
Yes, ma'am, absolutely. That's a cost that would be borne by all working interest owners.
In your opinion, would COG's proposed unit cause less environmental impacts than the alternative?
Yes, ma'am.
And will COG's proposed unit prevent surface waste more effectively than an alternative that involves multiple spacing units?
Yes, ma'am, it would.
Will COG's proposed unit prevent economic waste more efficiently than a situation where COG would have to use multiple spacing units?
Yes, ma'am.
And will COG's proposed unit best protect human health and the environment?
Yes, ma'am.
And that would be, it would provide better protection than a situation where COG has to develop 2 separate spacing units. Is that right?
In the scenario of the 2 separate spacing units, that is correct.
Okay. Let's look at the impact on well spacing and production. Can you identify this document that's been marked as COG Exhibit 18?
Yes, ma'am. COG Exhibit 18 is a gun barrel diagram that shows COG's proposed spacing in comparison to spacing that would be required if COG were to break it out into multiple spacing units.
Was this exhibit prepared by you or under your direct supervision and control?
Yes, ma'am.
Can you explain what's shown by the gun barrel diagram on the top left side of the exhibit?
Yes, ma'am. So this is a gun barrel diagram of the subject project area. The black circles represent the existing parent wells. The gray circles represent the project as proposed by COG, and the yellow circles represent the adjustments that would be necessary to drill outside 330 of the center line in the event multiple spacing units are created.
And what is shown on the bottom left side of the exhibit?
So navigating to the bottom left of the exhibit, we've created a diagram to help illustrate spacing, which can be seen on the x-axis in relation to recovery factor that can be seen on the y-axis. The visualization describes the objective of optimizing resource, which you can see on the top graphic. So recovery factor decreases, moving away from the wellbore. So spacing wells too far apart will result in suboptimal drainage of the reservoir, as represented in the bottom graphic, while spacing wells too close will simply result in reserves acceleration and overcapitalization of the project.
Based on this information, is it your opinion that COG's proposed spacing would more effectively produce the reserves underlying the unit than an alternative that involves separate spacing units?
Yes, ma'am. The proposed spacing is intentionally designed to efficiently drain the reserves and not infringe on the correlative rights of our neighbors.
Can you explain what's shown on the right side of the exhibit?
Yes, ma'am. So scanning to the right of the slide, this diagram examines the implications when considering various scenarios in alternative zones. So labeled are various common spacing stacking arrangements. The red circles would represent wells that would not be compliant if two separate spacing units are created because they fall within 330 of the center line. So these wells would most likely be dropped from the program. The setbacks impose artificial barriers, really, that would motivate operators to suboptimally develop resource that will ultimately result in wasted reserves.
Couldn't COG just seek approval of unorthodox well locations?
Yes, ma'am, but there's no way to know if these applications would be approved. And again, that carries serious business risk.
And if they weren't approved, would that result in waste?
Yes, ma'am.
Based on your professional training, education, and experience, is COG's proposed spacing within the 960-acre unit the best and most efficient way to produce the reserves underlying the acreage?
Yes, ma'am.
And would the proposal using the 960-acre unit best prevent waste and protect correlative rights?
Yes, ma'am, it would.
What is your understanding of the purpose of the division setback requirements?
To simply avoid draining the tracts that surround a given spacing unit.
And within the 960-acre unit, do COG's proposed wells comply with the division setback requirements?
Yes, ma'am, they do.
In your opinion, will the location of these proposed wells within the 960-acre unit impact the tracts that surround the unit?
No, ma'am.
And would the location of the wells, since they comply with the setback requirements, impact at all the correlative rights of the owners in the surrounding tracts?
No, ma'am.
A couple questions for you about multiple wells within a spacing unit. Is it your understanding that the division's interpretation of the rule would effectively require one well per spacing unit?
Yes, ma'am, that does appear to be the case.
Do most of COG's spacing units involve multiple wells?
Yes, ma'am, absolutely. So the majority of COG's spacing units involve multi-well simultaneously developed projects.
And why is that?
So the industry has really transitioned. Technology has evolved. Technology such as multi-well extended reach pad drilling and simultaneous completions to co-develop in order to prevent waste, protect correlative rights, and the very reason we've constructed the horizontal well rules.
And is multi-well, multi-pad drilling often the most efficient way to produce the reserves underlying acreage?
Yes, ma'am, it is.
and those methods then most effectively prevent waste and protect correlative rights?
Yes, ma'am, they do.
In your experience, do other operators also routinely include multiple wells in a spacing unit?
Yes, ma'am, this is common industry practice in my observation.
And would it be less efficient and ultimately less productive to have to limit spacing units to 1 well per spacing unit?
Absolutely, it would. A single well in a spacing unit would ultimately guarantee waste.
Mr. Angelos, can you please summarize your opinions and conclusions?
Absolutely, Ms. Hardy. In conclusion, I think I'm of the opinion that COG's proposed unit and well spacing will best protect correlative rights, prevent waste, and prevent the drilling of unnecessary wells. Additionally, it will prevent surface economic waste and best protect human health and the environment. That's all.
Thank you. Madam Chair, I move the admission of COG exhibits 17 and 18.
Any opposition, Mr. Tremaine?
No objection.
Commissioners?
No objection.
No objection.
All right. Oh gosh, you said 16 and 17, right?
17
and 18. Sorry. Exhibits, COG exhibits 17 and 18 are entered into the record.
Thank you, Madam Chair. I have no further questions for Mr. Angelos and tender him for questions from Mr. Tremaine and the Commission.
Okay. Mr. Tremaine, do you have questions?
I do have a couple of questions, Madam Chair. Thank you. Mr. Angelos, thank you for your testimony. I have just a couple questions about, you testified as to the, to a certain extent, to the notice burden that applies to the application and to the spacing. And so I just want to clarify your concerns there. Am I understanding correctly that COG's position is that there would be a burden placed upon it by having to issue notice to interests in tracts surrounding the proposed spacing unit?
The argument, and I'll leave it pretty simple, is more of a business risk, not necessarily as much of an administrative burden. So this will allow offset competitors leverage in ongoing negotiations that are common within the business.
Thank you for that. And just to clarify, that concern applies to a situation in which COG files a non-standard application, correct?
Yes, sir, Mr. Tremaine, that's correct.
And so the COG's concern there would not apply if COG submitted standard spacing units.
Yes, sir, that's correct.
Okay, thank you. And in the event that COG submitted a non-standard horizontal spacing unit application, in that situation, COG could utilize its existing development plan that's referenced in this case, correct?
Yes, sir.
Okay. And again, just to clarify, you referenced some spacing and footprint concerns and increased exposure to fugitive emissions. And I want to make sure that I'm clear on this. So your concerns about that spacing and footprint are relevant if COG pursues separate standard spacing unit applications, correct?
That's a good clarifying point, Tremaine. Yes, Mr. Tremaine, that situation would be in the scenario of two separate horizontal well spacing units.
So by extension, that concern does not apply to a situation in which you were pursuing a non-standard unit application and utilizing your current development plan?
Yes, sir.
Okay. And will you acknowledge that OCD's practice and rules do permit infill wells within standard spacing units?
Yes, sir.
Okay. So I just want to make sure that it's clear that you agree that under OCD's interpretation, the spacing units would be defined by a single well, but it is possible to develop standard spacing units utilizing more than one well.
Yes, sir.
Okay, thank you for that. In terms of, I also heard you testify to the extent that there may be some concern on COG's part that OCD is not guaranteed to approve subsequent applications. Is that correct?
Yes, sir.
It's maybe a better way to phrase that would be you have a concern that there's a potential business risk because you have to resubmit an application. Is that fair?
Yes, sir.
Okay. Would you acknowledge that there were not questions or any technical issues raised at the hearing for the application?
From a technical standpoint, that would be correct.
Thank you. And would you also agree that there is nothing in the record of this application or the Oil Conservation Division's order rejecting the application that suggests that OCD would reject the application or object to components of it on technical grounds?
On technical grounds, that is correct, Mr. Tremaine.
So your concern and the potential business risk related to submitting a new application amounts to the burden that's placed upon COG by resubmitting an application and the hypothetical that it could possibly be rejected, but there is no basis to say that OCG has indicated it would in fact reject the application.
From the OCD, and again, though, we do have a business risk from other offset operators in the event that we were to notify in the event of a non-standard spacing unit.
Okay. Thank you, Mr. Angelos. I don't have any further questions for you.
Thank you, Mr. Tremaine.
Commissioners, do you have questions?
No questions, Madam Chair?
Madam Chair, no questions.
Okay, I just have a couple. Is there anything that COG does that doesn't have a business risk associated with it?
That's a fair question, Madam Chair. There's, I think every day we run across business risks that we deal with accordingly. And we do our best to mitigate those every opportunity we get, which I think is what our original intentions were here.
Okay. Are you the correct person at this point to ask questions to regarding the rules and statutes?
No, ma'am. I would redirect you to counsel.
Madam Chair, I think Mr. Solomon testified about land and policy issues, but I think the statute and rule questions really would be legal ones that we would address through briefing or on argument.
Okay, because I guess I have a handful of questions on, you know, the statute and the rule pieces that haven't been addressed, and that seems to be the crux of this entire case. Okay, well then I don't have any additional questions. Thank you.
Madam Chair, I do have one quick one.
Okay, go ahead.
So Eric, a quick question for you is, have you seen any precedents where NMOCD have rejected similar applications in the past?
Dr. Impoma, that's a good question. I can't speak to that. I don't have that information in front of me at this time.
Okay. So you talk about there's going to be a 21% increase in facility use, and then thereby also increasing cost. So can you tell the commission in terms of if you are going for standard and then compared to non-standard, in terms of the revenues that will be generated for the state? Do you know?
That's a great question. I don't have the revenue number. From an incremental cost standpoint, approximately $3 million additional to the capital expenditures.
No further questions. Thank you.
Thank you.
Madam Chair, we can't hear you.
Oh, I'm just talking to myself. I just said thank you, Mr. Angelos, and you're dismissed for now, but we may recall you if we have additional questions.
Thank you.
Madam Chair, I'm sorry, I did have a couple redirects. that
Oh,
would be brief.
shoot, I'm sorry.
That's okay.
You're not dismissed.
Sorry, Mr. Angelos.
Sorry, Ms. Hardy. Go ahead.
That's okay. Mr. Angelos, to be clear, if COG proposed standard spacing units with orthodox well locations, it wouldn't be able to use the development plan that it's proposed in this case. Is that correct?
That's correct.
Because it would have to propose multiple spacing units or unorthodox well locations.
Correct, either or.
Okay. And there's no way to know whether those applications would be objected to or approved, correct?
That's correct. Yes, ma'am.
Okay. And I think I stopped sharing, but let me share my screen again here. And I'm putting up here exhibit 18. So is it correct that that exhibit shows that using orthodox well locations within multiple standard units would result in waste?
From this exhibit, that is correct. Again, panning over to the right, we've shown the implications that are far-reaching of that interpretation of the rule even beyond this project. Looking on the left side of the gun barrel are more of the direct implications that we're talking about today.
And again, if COG had to use multiple standard spacing units and or unorthodox well locations, that would result in additional surface facilities that you have shown here on exhibit 17.
Yes, ma'am. In the case of multiple units, that would be correct.
And you were asked a question, I think, by Mr. Tremaine about notifying interest in the surrounding tracts. And I want to be sure it's clear that, well, let me ask you this. Is it your position that the parties in the surrounding tracts are not impacted by your proposed unit?
That is my position, as proposed.
So
correct.
Okay. And so their correlative rights aren't impacted because your wells are within the setback requirements of the division. Is that right?
Yes, ma'am. And they're within 3 times of the setback requirements.
Thank you. Those are all of my questions.
Thank you, Ms. Hardy.
Thank you. Okay, now you're dismissed, but we may recall you if we have additional questions.
Thank you.
Thanks. Ms. Hardy, do you have any more witnesses?
I do not, Madam Chair.
Okay. Mr. Tremaine, do you have any witnesses?
Well, I did not plan for any witnesses, but I would proffer that the OCD has been routinely approving non-standard units, and the OCD is not aware of objections to those units. However, I'm not a witness, and so I don't expect you just to take that purely on my representation. So it may be appropriate that if that is of concern to the commission, that I could follow up with related information.
Okay. I guess Mr. Oh my gosh, I'm blanking. Crying Camp, sorry. If we have questions for Mr. Tremaine, can we just ask Mr. Tremaine? Or
You can, but like he has indicated, he's not under oath. So, I mean, he's free to, make representations to you, but it's not, formal testimony.
Okay.
But I would also say that I note that you had some questions that you wanted to ask. I think both parties about statutes and regulations, and I think that that's perfectly appropriate. My recommendation on that would be that you might do that through as part of closing statements. you could ask questions at that time. That might be the simplest way to do that.
Okay. Yes, with that, commissioners, do you have any additional questions for any of the witnesses at this point?
Madam Chair, I do not, but as I'm thinking about how we close this out, I'm wondering if, and perhaps you're already thinking this, but if we want to have written closing statements, I think that'd be helpful to me. And it sounds like you have some questions that you wanted to see addressed. So that with y'all.
Madam Chair, if I may.
Go ahead.
I mean, one option would be sort of a hybrid of both. You could sort of have the opportunity for the parties, the attorneys, to make their arguments, and you could ask any questions that you have, and then you could let both parties follow up with written closing statements. That, you know, might give you everything you're looking for.
Okay.
Madam Chair, so I do have some questions for OCD. So I don't know how it can be answered.
So why don't I kind of like the hybrid option. Do closing statements. The parties can both do closing statements. After your closing statement, the commissioners will have an opportunity to ask questions. And then I'm kind of thinking we do written closing statements, but with a cap on page number, and potentially an emphasis on the rules and statutes and any sort of previous precedent. Commissioners, does that make sense?
Yes.
Okay. All right. I think
Madam Chair, one last recommendation as far as the closing statements / oral arguments go. I also might suggest, just for the purposes of doing this more like a court would do it, you might have Ms. Hardy go first, and then followed by Mr. Tremaine, and then give Ms. Hardy a brief opportunity for rebuttal. That's, you know, most like what the courts would do under, you know, in a case like this, and so that might be helpful.
okay. Ms. Hardy, would you like to make a closing statement?
Yes, Madam Chair, I would. And I agree with, I think it's a good idea for us to provide written closings as well. Madam Chair and commissioners, COG is not asking to ignore the rule. COG has a good faith disagreement with OCD about the interpretation and the application of the rule. And the bottom line is that the rules and regulations have to be construed in conjunction with the Oil and Gas Act to prevent waste and protect correlative rights. And when those are all considered, the logical outcome is that the rule that the division has relied on can't be construed to apply just to one well in a spacing unit or one proximity tract well within a spacing unit. The provision of the statute that OCD has relied on, 70-2-17B, which discusses proration units being established for a pool, does not control here. The horizontal well rule is very specific in that it applies to spacing units, and there's a difference between spacing units and proration units. And we're not here establishing a proration unit for a pool, which is what that statute applies to. So when you look at the language of the rule, and we've addressed it in our pre-hearing statement, and we'll address it in our closing written statement as well, when all the provisions of the rule are read collectively, it really has to be construed to allow these proximity tract units that involve more than one proximity tract well. It just doesn't make sense to limit it in the way that the division has proposed. And in today's world of multi-well pad drilling, it doesn't make sense either. And the purpose of the rule being adopted was really to allow flexibility for operators in best deciding how to develop their acreage. And here, COG's proposal, I think our testimony's established, and it hasn't been disputed, that it would accomplish that result. It would best prevent surface waste, waste of resources, environmental waste, and it would also protect correlative rights. And although COG could apply for a non-standard spacing unit or for multiple spacing units that involve unorthodox well locations, there's no guarantee that those would be approved. And I don't think it's a dispute that the division does approve those, and it can. I don't think that's the issue here. I think the issue is that they may not be approved, and it depends on what other parties object to, and they result in delay and make it an ineffective way to develop this acreage. And if the applications were denied, as Mr. Angelos has stated, that would result in waste, and it would not protect correlative rights. So basically here, I think that when the rules are construed collectively in accordance with their purpose and in accordance with the Oil and Gas Act, COG's position is correct, and it is that the rule has to be construed to allow multiple proximity tract wells within a spacing unit, especially when that is shown to best prevent waste to protect correlative rights. So we would ask the commission to approve the application. Thank you.
Commissioners, do you have questions for Ms. Hardy?
Yeah, Madam Chair, quick one. So, Ms. Hardy, you talk about, the burden on getting approval, but so is that the main objective, or is that the main concern, or is it more on the business side? Because in your closing, you more or less stressed on that.
I'm not sure I understand your question, Dr. Akoma.
So in your closing, you talk about, let's say there's a possibility that the application might not or might be approved, right? But so is that the main concern for COG, or mostly on the business side?
I think COG's main concern and their objective here is to best develop their acreage in a way that would prevent waste and protect correlative rights. I think that's the objective, and I think that's what they've proposed to do. And I think we've also shown that the interest in the surrounding tracts aren't impacted. So it just doesn't make sense. It's sort of, it just doesn't make sense here to notify interest owners in the surrounding tracts when your proposal doesn't impact them and it doesn't impact their correlative rights. It's sort of an arbitrary procedural issue that's inconsistent with the purpose of the rule, which is to allow for flexibility and allow operators to best develop their acreage to prevent waste and protect correlative rights.
Yeah, will you please include in your closing statements, the written one, how COG believes that their operations will not impact any adjacent tracts?
I think we've presented technical testimony today on that. Is there some additional information? I think our engineer has testified to that. But if you have questions on that,
I will check it out. So thank you.
Thank you.
Thank you.
Any additional questions, commissioners?
No, Madam Chair, thank you.
Ms. Hardy, can you explain to me how the proposal is a standard horizontal spacing unit, and how basically how it can fits in with the rule so that it's a standard unit?
Yes, I can, Madam Chair. So the rule talks about standard horizontal spacing units for horizontal wells, right? It's 19.15.16.15b, and subpart A states that the horizontal spacing unit shall comprise one or more contiguous tracts that the horizontal oil wells completed interval penetrates, each of which consists of a governmental quarter section or equivalent. So, and then on subpart B states that you can include the proximity tracts. So it's our position that when you apply the rule and you construe it in accordance with its purpose, it allows multiple proximity tract wells within a spacing unit. Because if the rule was construed literally, where it says the well or a well, if that were construed to mean that there could only be one proximity tract well in a spacing unit, other provisions of the rule would have to be construed that way as well. And they clearly are not, because multiple wells are included in spacing units all the time. And I don't think anyone has alleged that they can't be. That's just the way that horizontal well development is accomplished at this point. So, if you're looking at subpart A2 of the rule, it says each horizontal well shall be dedicated to a standard horizontal spacing unit or an approved non-standard spacing unit. But the rule is not interpreted to mean that only one well can be included in the spacing unit. But using the division's interpretation of subpart B, that would be the result. So basically, we're arguing that the interpretation of the rule means that multiple proximity wells can be included in a spacing unit, and that best comports with the Oil and Gas Act's obligation to prevent waste and protect correlative rights. Does that answer your question?
Yeah, and so my similar question would be, let me pull up the, how do you so that was on the rule front. All of our rules are derived from statute, which I think in this case is NMSA 70-2-17B. And is that what you were saying was more related to proration units?
Yes, Madam Chair, because the provision specifically states that the division may establish a proration unit for each pool, such being the area that can be efficiently and economically drained and developed by one well. And that is the provision that the division cited in their pre-hearing statement. It was not cited in their order. The order only cited the rule. But their pre-hearing statement did cite that provision, but it's not referring to this situation. So I don't think that statute is the controlling one here. I think here we're looking at the overall objective of preventing waste and protecting correlative rights.
Okay. And you believe that I think orders R21089 and R21055 set precedent for this?
That's correct, Madam Chair. Those were similar to almost identical situations where the units were approved.
Okay. I don't have any additional questions from Ms. Hardy. I'm sorry, commissioners, do you have any additional questions before we go to Mr. Tremaine?
No, Madam Chair.
No, Madam Chair.
Okay. Mr. Tremaine, would you like to make closing statement?
Yes, please, Madam Chair. So I'll start off by saying that there are a number of points where OCD and COGA actually agree. I think this really comes down to a dispute regarding which section of the statute controls, because COG is essentially arguing that the section referenced by OCD does not control the definition or limitations placed on horizontal spacing units. I don't think that follows through in a reasonable way, because spacing unit is not, I don't see it otherwise defined within the statute. And the statute although proration units and horizontal spacing units, standard spacing units are different to one extent. Those terms are used interchangeably in the statute. So in terms of statutory authority, I think it's clear that the provision cited by the division defines the extent of OCD's authority to define those standard spacing units. The standard unit is defined, as we've already been over, by the tracks that can be produced by one well. And I do concede that the language in the section specifically refers to proration units. However, I think that it's clear from the construction of the statute that that applies to standard spacing units, and the lack of other direction does not allow OCD to look to another provision to define spacing units in a broader fashion. That is defined by all tracks that are penetrated by the lateral in terms of quarter-quarter sections, and in this case, there's no dispute that the proposed well's proximity to the quarter-quarter boundary line allows COG to bring in the additional acreage quarter-quarter tract. So we're talking about adjacent 40-acre quarter-quarters along the length of the lateral. For the purposes of statutory authority, I would just reiterate that the Oil and Gas Act treats those terms, proration and spacing units, interchangeably, and so that's what should control here. Similarly, the structure of the Oil and Gas Act, I think, clearly treats standard and non-standard units differently, and that's been reflected in the rule. So the proximity rule promulgated in 2018, to get into the history a little bit, I mean, that was promulgated after extensive outreach and collaboration with industry. I don't think that a fair review of that record, that process, that hearing, allows for a conclusion that anyone, either industry or OCD at that time, intended to treat development such as proposed here as a standard unit. The language of the rule very clearly refers to a single well, which is consistent with historical practice, and I argue consistent with the construction of the statute. More importantly than that interpretation of the intent is the fact that the language of the rule is consistent with OCD's interpretation of the statute. It's consistent with the language of the statute, the plain language. This is not an area where I think there's a great deal of leeway for interpretation. You know, COG provided some testimony related to correlative rights. And I think that this argument, the way it's presented from OCD's perspective, is backwards. Essentially, the fact that the statute treats standard and non-standard units as distinct, and pursuant to that statute, the Commission has promulgated rules that require different notice requirements for standard and non-standard units. I would argue that there is a potential impact to surrounding tracts as a matter of law, not as a matter of technical basis, but as a matter of law. Before 2018, a standard spacing unit was a 40-acre tract. So the 2018 rule brought the rule up to modern practice, but within the context of the statute enacted in 1977. So it's not, you know, there's a limitation on how far that can go. And I think the issue with correlative rights, even if the Commission is concerned or gives weight to COG's argument about the lack of demonstrated impact to correlative rights, that issue is a general matter under the statute. The general provision does not supersede the specific language cited by the OCD. And further, the technical testimony about the actual technical impact of the proposed development on surrounding tracts, those representations should not control this analysis. I think that if there is an interpretation of the legislature's intent with these provisions, is that standard and non-standard wells should be treated differently. I think that's reflected and consistent with with the Commission's promulgation of the notice requirements and the rules that we've been discussing in detail. COG also put on testimony related to business risks, the burden and the potential risks associated with notice to tracks outside the standard spacing unit as proposed. You know, I'm not going to delve too much into those policy arguments. I will maintain that this determination hinges on a legal analysis. However, I think it's necessary to point out that the policy concerns are not one-sided in this case. This is not a set of compelling policy arguments presented by COG without counterpoints. In fact, I'd point out that standard horizontal spacing units that do not involve compulsory pooling applications do not necessarily have to go to hearing. Further, under COG's interpretation of the rules, there is no limit to a standard spacing unit. So those would only go to hearing and be noticed for hearing if they involve compulsory pooling units. So if the Commission is considering the policy implications of COG's argument, I would present that the policy implications for their interpretation actually outweigh the concerns raised by COG, which amount to business risk, essentially. You know, I think that the bottom line here is that COG's interpretation and their presentation amounts to their belief that this production plan is the best way to develop this acreage. Further, the rest of their arguments, I would suggest, are strong arguments in support of a non-standard spacing unit. I see no indication in the record, and I'm certainly not making any representation that OCD has any concerns, excuse me, if it meets the appropriate definitions of a non-standard spacing unit, and it provides the appropriate notice to the potentially impacted parties surrounding the acreage. I need to follow up too regarding one of the points Ms. Hardy made regarding the wells. There's no limitation in a standard spacing unit to utilize one well. And you know, the rule that she referenced, I would ask the Commission to go back and review the entire section of the rule, because it does provide for language that says except for infill wells or multilateral horizontal wells. So the issue here is not, is COG going to be prevented from utilizing multiple wells to develop the tracks in the event that they pursue standard unit applications? They could still use multiple wells. I'm not going to get into whether or not their development plan needs to be tweaked, but they can still use multiple wells as provided for under the rules and is consistent with OCD orders approving such applications in the past. Frankly, I think that this application makes a lot more sense as a non-standard unit application, and don't foresee any technical issues with that. And OCD cannot contemplate or incorporate into that analysis what competing businesses might in fact do at that hearing. If necessary, I can try to provide some more information about objections to non-standard applications, but I don't believe it's supported historically that those are objected to on those grounds. Further, to the extent that COG is making policy arguments, this is not the venue for that, because we're talking about a specific interpretation of the statute and the rule that was promulgated pursuant to the statute. They may have valid arguments to present to the legislature to ask them to update the statute. But as of right now, standard units are of a certain size, you know, up to 40 acres each side of a lateral, and COG's interpretation will put no limit on the size of a standard unit. I think that outcome, in the face of the construction of the statute, flies in the face of both the plain language and what I think is the apparent intent of the legislature when they enacted that provision. That's all. Thank you, Madam Chair.
Thank you, Mr. Tremaine. Commissioners, do you have questions?
Madam Chair.
Madam Chair, I do. In OCD's initial statements, and you repeated that, you said the flaws in COG's application cannot be cured through hearing. So, I think the clarification that I need from OCD is COG referenced two orders, the R21089 and the R21055. So can they really explain to us how they approved these orders, which COG is arguing is similar to this particular case, but they want us to deny this application?
Thank you, Commissioner Ampoma. I think that's a great clarifying question. So I want to first clarify that my statement in opening and in a pre-hearing statement is that to the extent that this cannot be cured through hearing, what I mean by that is that it cannot be cured through this hearing. So OCD's position is that it needs to be reapplied, properly noticed, and then go through the proper hearing. So in a sense, it can be cured through hearing, just not this one. In terms of the other cases, I acknowledge that those were styled as standard cases. I thank Ms. Hardy for clarifying that in cross-examination. Those were approved. But I think we need to be clear about what that argument stands for. Essentially, if the commission concurs with the division's argument today, that those are not permissible under the standard spacing, what that means is that OCD erred in the previous cases. That should not stand for the proposition that it should do so again. That's not legally supportable. I leave for another day what corrective action would be necessary in those cases. I'm not sure how that should be approached, to be frank, at this time. But I think that the argument is essentially you missed it in the past, so you should agree with that and do it again. I think it's clear from those orders, if you review those, that the division did not intentionally take any position that this was in fact a standard unit. I think essentially they missed the distinction in issuing those orders. So that's where I would draw the line. And I would say that to the extent that those are in error, that the OCD should not and the commission should not replicate that error in the future.
I want to know if, let's say, the laws that you talked about in 2018, were these standard wells approved prior to the 2018 rule?
I'm going to try to answer that. I don't personally have historical knowledge of what was approved before 2018. What I can speak to that's clear from the record is that prior to the proximity well rule promulgation in 2018, all laterals were treated as non-standard units because a standard unit was defined as a single quarter, so it was a 40-acre tract. And actually, you don't have to rely on my representation for that. Counsel for COG cited the Jalapeno case in their pre-hearing statement. That's reiterated and outlined in that case. I think it's very clear that there was a extreme limitation on the acreage because the prior rule, and for that matter, the prior versions of the statute, were focused on vertical wells. And the 2018 rule amendment brought the standard spacing unit up to the modern day to deal with laterals. So I don't think that those, I would logically have to conclude that those were not approved as standard prior to the 2018 rule. My understanding of the practice is that they all went to hearing as non-standard if the operator was proposing laterals.
Yeah, another question is, as you went through your closing statement, you talked about how COG can still be able to more or less complete this development using the non-standard application, combined with infill drilling. Can you clarify that that assertion?
Yes, the infill well issue and multilateral well issue that I referenced, I think that applies more appropriately to a situation in which that's my attempt to clarify that this argument around standard applications. So if COG pursued a standard unit application, like, and this is 960 acres with the two based essentially on two wells in proximity of the quarter boundaries. So you have 480 acres on each side. And from what I understand from, I believe it was Mr. Angelo's testimony, is that they're going to have a problem drilling that middle well because it would be between two standards. Well, what I'm saying is if they did pursue two standard unit applications, they could still use infill wells. I'd have to refer to provide someone for technical testimony, I think, to answer the question of could they actually use that middle well between the two standards. I don't think I'm prepared to answer that. But from a legal standpoint, they can in fact use multiple lateral wells and multiple infill wells as appropriate within those two standard spacing units. So that was my attempt to clarify that. If they pursued a non-standard unit application, there would be nothing to prevent them from using their proposed development plan as it exists in the current application. The difference is they have to apply for it by calling it a non-standard unit application, and they have to notice the surrounding tracts. I mean, that's really the only difference. I'm not aware of any point in this record or the history of this case where there have been technical issues raised about the use of any of the wells, any of the proposed wells. It is possible, I guess I should clarify also my previous answer, that regarding the well down the middle between the two standard units, if they had the two standard units, it is possible that that COG could use apply for a non-standard location for that well. But again, I go back to the plain language and the what I think is clear, the intent of the legislature, that standard units, at least under this statute, only extend to a certain size.
Yeah, so lastly, so is NMOCD's position is that if they made a mistake in the past, they certainly do not want to make the same mistakes in the future. Is that the argument?
Yes.
Thank you. Thank you, Madam Chair. No further questions.
Thank you. Commissioner Bloom?
No questions, Madam Chair.
I think you answered all of my questions in your previous questions, Dr. Impoma, so I don't have any additional questions. Ms. Hardy, do you have any rebuttal statements?
Yes, I do, Madam Chair.
Go ahead. Thank you, Mr. Tremaine.
Thank you. A significant portion of what Mr. Tremaine just said involved, I think, technical testimony and opinions regarding COG's technical testimony when OCD did not identify a technical witness and didn't present one. So I don't think it's appropriate for counsel to make technical arguments and present what's basically technical testimony. So I think a lot of what Mr. Tremaine said falls into that category and really can't be considered on that basis. I think it's not appropriate for council to submit evidence. The prior orders that we've talked about are absolutely precedent. And I know that Commissioner Ampona asked about those. Those were approved. One of those orders is from 2021 and the other is from 2019. So those were approved under the current version of the horizontal well rule. And at that point in time, OCD concluded that those applications should be approved as standard horizontal spacing units. And it says that right in the orders. So it's not correct that it wasn't clear what was being approved. I think it was very clear what was being approved, and they were approved as standard spacing units. And so this situation really is no different, and this unit needs to be approved as well. And operators absolutely rely on those orders in their development plans, and they expend significant funds and make development plans based on the division's orders. And that is certainly true here. So COG, and I'm sure other operators as well, have been planning their units in reliance on these orders. And now OCD wants to change the way that it interpreted the rule. One thing I want to be really clear on as well is that the statute that OCD really, I think, is relying on for its argument is 70-2-17B. And again, that statute refers to proration units, which really were a concept associated with vertical wells. With horizontal wells, we no longer have proration units, and that's why the horizontal well rule applies specifically to spacing units. There is a difference. And of course, that provision of the Oil and Gas Act predated horizontal wells and horizontal drilling. So I think it's incorrect in this situation to conflate those two concepts, a proration unit and a spacing unit. And I think that the provision of the statute doesn't support OCD's argument for that reason. And when you look at the statute in its entirety and you construe that in conjunction with the rule in its entirety, the only reasonable conclusion is that a proximity tract unit can include more than one proximity tract well. And in this case, certainly COG has established that that is the best method of development to prevent environmental, surface, and resource waste, and also to protect correlative rights. So on that, we would ask the commission to approve the application. And I'd be happy to address any other questions and address any specific questions in our post-hearing submission. Thank you.
Thank you. Commissioners, I think, we're talking about doing written closing statements. I would love to put a cap on them. No more than 10 pages. Yeah, maybe. No.
I'm comfortable with that, Madam Chair.
Okay. All right, our next regularly scheduled meeting is, I believe, the 12th. When do we want these? I think at least a week in advance.
Yeah.
So that would put it on the 5th.
Okay.
Okay.
That's fine, Madam Chair, thank you.
So then I would move to have council, or in case number 22294, have council draft written closing statements no more than 10 pages due to the commission by end of day on the 5th. Is there a second?
Second, Madam Chair.
Mr. Krankamp, would you please do a roll call vote?
Yes, Madam Chair, I can do that. I saw that Mr. Tremaine's hand was up. I'm not sure.
Oh, I'm sorry.
I just have a question of order.
Yeah.
Is the 10 pages inclusive of exhibits or not?
Good question. Non-inclusive of exhibits. So let me make a new motion. In case number 22474, we are asking for written closing statements, no more than 10 pages, not including exhibits, due by end of business to the commission on the 5th of May. Is there a second?
I'm sure I second.
Okay. Would you do the roll call vote, please, Mr. Krankamp?
Yes, Madam Chair. So on the motion, with respect to case 22474, Chair Sandoval,
Approved.
Commissioner Bloom,
Approve.
and Dr. Ampoma.
Approved.
Madam Chair, the vote was unanimous.
Thank you.
Madam Chair, I apologize. Can I ask one question for clarification?
Yeah.
I'm concerned about the submission of exhibits that weren't considered in the record. I'm not sure what exhibits we would be submitting with our post-hearing briefs that wouldn't be in the record.
Madam Chair, this is John, your temporary counsel. I do think that because the hearing record is closed, with the exception of closing statements, that concern's probably well-founded. I think to the extent that they wanted to attach exhibits of documents that were already part of the record, that would be, I think, fine, because those are already in the record. But I don't know that closing statement is a procedural vehicle to introduce new evidence into the record, for either party. So that would be my interpretation of that.
Okay. Does that answer your question, Ms. Hardy?
It does. Thank you.
Okay. Well, I guess I will see both of you back here on whatever that day was. What day is that? 12th of May.
Thank you, and thank you for your time.
Thank you.
Thank you. All right, agenda item number 9. Is there any pending litigation update, Mr. Krankamp?
Madam Chair, there's no pending litigation update that I was instructed to deliver.
Okay, thank you. Any other business before the commission today? All right, our next meeting is May 12th, 2022. And with that, we will see everybody then.
Bye.
Thank you.
Thank you very much.